That's right. Chemekanyame. Mimba nyefe nye de omanye mene ashi ho nima ho nama ho wanda okleje ma weshi ake egbelewo ni mene nwe ekemene ekewo ake obatabie ni noni esani mambi anue wonu enwo na wa ake okleje ma we echuwo ni jema wajin ke sisa efe hu ame pia neke nuchu monese ake ame ba wo yiwale bonia fe ni waka no kwale anme mambi ahi tomobeni nke ebwe inanoko nye ni it is the more reason yewo ni neke judgment ne kefie keni ne ini ne sheno isani matabie ni makande keji noko woko miye wale akeshi iya no ni nkane ne ken judgment ne instead of matabie peni makebwe no ni nanye ewo miye wale wa ake it is something that I should or I must, as a matter of fact I shall do, because nye biamini kole we yafanga ina nibi ekome nibi kome ni na kedabi semi we press conference semi nibi kome na yue na kedabi dabi wanyeme pi ni amele nibi kome ni me take advantage of it ni no ni bi ayawo mami knowing very well like wanyeme they don't have a way of figuring out whether no ni akọ me alo no na me no anukwale ni alo je anukwale ni iname na nye chei me komenye dadei keni bi bige bi bio jimi ken na fofosa inako ni afangma ni oblahin bi ko blaje bi anye kusun chema ase tamaboni nye inale nakanoe inako ekodan ikegbe me fojin ni amebe kusun felo aten amenye neke kusun nye se solo boni amenyo ni solo ameni femoy. What I saw yesterday was an eyesore. And every well-meaning gano, no the machine, you should condemn no nite no, ye call with my family. The masses, be amina fe kusumi masses say, ni Allah kamena menye say, ame fe ni to mo political campaign. Like, what the fuck are we doing? Excuse me. Afeni to my political campaign. Ni our campaign can have one candidate. Look, many of any me diame. Ibla min chonye. In la talk panga ye kolewe. So they are all my brothers. As a matter of fact, between Nuumo Ayitey Cobblah, can Nuumo Okai, ike Nuumo Ayitey Cobblah ye find wa. Ike le you several times. Ikele ye find your joke bang. So keje sanima support mokwe. It's probably Nuumo Ayitey Cobblah because Ikele ye find. She no ne eja. Inke mie inyo anukwale se. Ne waka anukwale yo se bonke baya. Ke anukwale bo se. It does not matter the sort of relationship that I have with you. It does not matter. Cheme okleje efo mi mu ni matabie ni mbidi nchema fe no ni mi ntwi isumu okleje efo mi mu ni yo ya ke jema wagin ke sisa enwe jo mi ni matabie ni mayu anukwale no akenka bo ye fine ni anukwale e boss e de nche inye mayu e ko mahabo. I cannot not to say again Nuumo Ayitey Cobblah ekpa mi fight. I can you ekonyale dabi. She noni na nye ebe wakusum fe momli. nako ni afanga ni mafa echo a political campaign. A campaign, two candidates now. Maybe wakusun chomo wakusun femo campaign. And you have people actively campaigning for Nuumo Ayitey Cobblah as if this is politics. Mokwe team A, ni mokwe team B. Wake kusumi chuni don. Wake mla chuni don. Ke kotu we no kwe esa ni wabuo don. Wadi ncha wabateshi ni wabafeno ni wasumo. But no ni domine feni nimi na oblantai ne kome nyeche. Nie kome nye that day can he be ready to actually, like, you cannot tell me these people weren't ready to hurt people. And nyeche oblantai nyeche ke that day meaning ke je Nuumo Okai we bi ya jejeme baba twa me cheke that day. Meaning ke Nuumo Okai we bi we ba jejeme ake ame win ye kote ni ame ba twa kusumi ye aba twa me cheke that day. What are we doing? What are we doing? What are we doing? Kate mafa biane anyo chei ke dade. Anye chei ke dade ye mafa se. Ake chei ke dade ye mafa se. And there are people me yegani ene me ngomena. Kame ene me ebamena. And you take it that day. And you know one thing. Oh, bene one fe Nuumo Okai. Di kepo. Thank you. Oblaye abi ke oblaye abi. Thank you. Again, I can give any. Oh no, oblaye abi ke oblaye abi. Anye cheikete. Ni no ni ya no fe ike Nuumo Okai etashidi. Nye kwa kenye na le traditional council epo di kepo. Nye na ne fe gbe ami traditional council po down. Nye na Nuumo Okai. Even nye na le ne ta traditional council nye na ne fe gbe ami important. Ke tashidin. Ni so far sane ne fe ni ya no ne fe tashidin. Ni ole seriously ke okwesane e ene ni adama la cheke Kevin Taki. Anu kwale e ko mepe. Ni adama la che Kevin Taki. Mokome no fe mo gidi mokome etashidin ege ke hamla no hamla ke tuni nge ko kwe ene ni adama la cheke Kevin Taki mokome ba gidi nyemi gidi ya na no mokome etashidin no fe no buemla atuni kele li encha ye won bi nchile poage ni o fe ble ocho sano wo no ege wo ke hamla nya ni mla ya na kan pepe. Same thing. Nuumo like to adi awushi. Ke Nuumo akwa minsa. Mokomi all over. Mokomi le we tashidin. So nye kwa position sete ni apele ye gan. Nye kwa candidate se many me ye din. Many they are all over the place, actively on social media and everywhere. Nyekwa, nye tashi di nyekwa. Position say ten ni apele ya gamashe. Nyekwa one group of people where ame suban keboni ame yo. And then the other group of people le nyekwa ame suban ka ame uboni ame yo. I don't have to tell you. Unke femo bolinche kwamo. And this young man, Nuumo Okai, he has been quiet. No basa. E engage no konokwe. Ke teshi din. Ke tashi din. Look, I admire him so much. I am telling you. I admire the way ni e comporte he throughout the kingdom. And look, this man, afaleke ku na kaino tumo ni adama la cheke tumo numo lago tiara ushi ku. Tafla che ake toy chule eduna. Ngemini ake toy chulo eduna. For what crime? For what crime? For those of you who as a matter of fact, I should have the pictures. I hope I can make a pictures. Ni one catch on ye. Ajile na fale ke klante na ke toy chole duna. This young man. Ake toy chaleshi. Tumobani nyena numo lago ti adawu ni adwa wishi ni agbala le toy ke ni biye matao numo kind picture say oni won ke ba chonye. Face he has been quiet. Now, what a lot of you do not know, Jiake, Moniji Korle Wulomo, aye omo, aye 2011 ton, na ye Nuumo Okai, aye, Nuumo Okai. Noni last week, aye, ne aniga, echene, nuale, ate, Nuumo Okai kete, koni, aje Nuumo Ayitey Cobblah yeshia. Because I hear alomo akeleji Korle Wulomo. Si kwa mo ekeje 2011 ni aje hale akeleji Korle Wulomo. Eba anye ya ne chue ni ake Korle Wulomo still etashidi. Efe ko basa echuko mena ataki Korle weshia still etashidi. Nuumo Ayitey Cobblah chuo no ne chuo ake Korle Wulomo. Nuumo Okai etashidi. Eke basa ya fan kole efe kono etashi win in 2011 ni a lot of people nye leno ni your 2011 judgment tell me maybe li ake sani ekpa ko aye no ye last week nkaba nkama bo wo ma sa ma ba bi e ko shike o ta no nushishi no ni aye last week it all started from this judgment ni member makande man habo 2011 judgment eba gbabo no fe no me waninka non jenshi habwe because nye tia me pia nye le call your machine nye nkwane nye le ake court to declare now oba bi ake if you take court to chon money ye wulomo you know what is funny jiake even in 2011 ni our judgment na in favor of Nuumo Okai ni sani agency in 2002 Nuumo Okai po lepo eke sa ni court to you. Because Wulomo sani netumo Manchester ni eluzu ame file appeal ame luzu akete Supreme Court enwe Nuumo Okai ame sa ame luzu again ni Supreme Court ake dabi Wulomo yeli je manche yeli ni wo court ye egbe ni ejio Wulomo sani so le monipo a win a win 2011 judgment no mi po esumo ni court tano. Because in maybe like ani Wulomo sani etefete na ya court le Nuumo Okai po no mi po ekpene chi court to eke dabi Wulomo sani je Manchester ni no court ye na ta Wulomo sani no nibi ni Nuumo Ayitey Cobblah kampe kete aga court we aywe ashi Nuumo Okai 2011 ton ame luzu poto nibi na me ka fon court we yin ake court we aywe ha me niji Nuumo Ayitey Cobblah e kampe 2002 ama me ke saniete e chemeni for the lack of a better expression I mean yes I mean na me kete against Nuumo Okai. Nuumo Okai was a defendant in the 2002 case ni at a travel around Qatar 2011 he was the defendant. Many may support Nuumo Ayitey Cobblah. They were the plaintiffs. I'm a saniete. But I'm a loser. Every single thing they were asking in 2002 na kesani ete I'm a lose pato any ole ken kan abue oba na boni game yo nke bomo ne nyami no egelele bomo ne nyami no kwe game kwe money tune what to find out wa I don't know bomo ne nyami no na ke menen le momin le papa le money fole egelele. Surely, if there is one thing that I took from this, is that truth will always overcome evil. Truth will always win. It may take long. It may not be immediate. But truth will always win. Ni kejo ya mashi ni obomitoe min kpabo fai ka fe noko ni sa no fio because moko elakabo ko e abani oba ya mon oba wo eko ni ekole keje bia mi na fabu e ogwa ko jendan. You understand what I'm saying? So min kpanye fai noni nyefe nye obla yabi Koblah yabi ni yo machine noni nyefe nye egamla kpagbe Nuumo Okai kaji eke e ba take no na fe nye on a lot of you will go to jail. You understand? Now nyeni ashi jama onu ni me pi we papo je sempe papo sete fote sempe ba Korle ni ko to eta no mi fe ayu na ken gbe papo e ene je ayu fe nke na me nchonye because in liake wonye me pi ni yo shin am attention span ye very short no ka mo ko phobia po ne ke ha me na papo e na ke chole eni papo e je agbla mi lelen aka chole papo shimini bana chole papo na mi inja wulawe yekpon mi nja awulawe yekpon jameje ni ncheje awulawe wo na chiche ya awulawe ya for ye wo adwa wayo laje. At least these are the three female names ni wo adwa wayo laje iyebi yo nchele adwa shi nileji yo kenklen esanima chele adwa. You find it, nyam 1 second. Thank you. What was over? No me ini hami charge ake etani egbo alonuko. Yes. Iyebiyo. Imbiyo kenkle sanima chele adwa. Chinchele adwa. Inwele na chiche. Mino ngwele na chiche. Inkele wo ina na kanswa ina mami. Mami lenwe mami. Leji na chiche. Awo na chiche ya otublo shinje ya otublo nwewo otoke mi ake ke awulawe wo yolumoko ye geme ne sani imbi ne sani ma wole na adwa ni wole adwa ni wole na chiche ke she no abaga chole na chiche wo eje awulawe chemeke nyame pakpo eni nyena na acho pakpo eno no mi ngla mi abo yi nke me die nchen for example ije pon awulawe awo na achiche egeme na achiche awo ya otublo hum mina na kanswa leji na achiche ni fo imbi yo klomo esanima wole na adwa shi wole na adwa wole na achiche otublo ungbeni because imma mina na kanswa gbe ninke wole ne wakeji wo ye noko ni wo yo ya wulawe ne sani imbi na achiche aye abakake because achole na achiche ewo beje adwa wedon eja awula wedon eje ekpo ndon eja awula wedon so pakpo na cho no ngba mi abu e so keji oyega ni ofobi ni oma oni nkogbe ona akogbe onye kwekogbe no kewole keji nye noko yelie alo esake nye noko e abaka because o chake obile egbe iwo na kanye ni nye yo es jemi minke no ni court weke no ni aye court we no nko bo jemi ni tete ntabie ni mi ba minke bonoko ni nken defend Nuumo Okai jemi nke eye court wolu ani makande ma abu emi ayuefe ya court wolu ani nkane akeme talashi ni abana aba bibi sane ni me gbla mi fe so no ni nko bo jemi iya twa Nuumo Okai yese ne gbla mi e chon mi ake efe neke court eye court wolu emi no ni nko bo bia ne nke eye court wolu eni makani abwe eye mi Nuumo Okai ye e chani fole e mami ji moni je sempe aje no he wande Nuumo Okai e chani fole e mami ji moni je sempe e mami keke efe nuwe e yegbe ne bawo ne fe yo enye wo na kan gbe e sumoni egbe ehun ba gbo because le afo ekome e papa ya afo ye e konklome shi le afo ekome ni ke nunji le e ba cha ni bia no e ba cha gbe no shi ne fe yo ewe enye no ni afo Nuumo Okai ye ni afe kusumi ne ke bile yue na wole papo e moko ba ka ke o eyenyemi akun no atefi oten na wole papo e kele la ke jejeme ne eyenyemi hu akun I hope ake yomu ye bi e yomu egbo iye yomu obituary ke no fe no bi e ni no hu e ba gbla mi hanye so pakpo na achole no ne sheche court e manomia ke eche je kolewe eni je kolewe enye me fe ye jame na me nchoni abia ke no kole mene tefi oten mene lo kelele ni mene ke mene fe nye komebi ke che komebi tefi oten no kwa kole mene ni mene lo kolele nye komebi ke che komebi e o kole mene ni mene lo kolele so ko bi mi ameshua me yen si poto ye kotwe ni I've been told one ke wono ni makane ma abu ele nwo nye ba na ke Nuumo Ayitey Cobblah we bi enwo ama ameshua me yen si poto ye kotwe no ni makane ma abu wo mi nkaneko kama tuni ye na kan fio nsumo na efe fresh ye ndwomo mi so no ni makane abu wo mi nkaneko ba ko na ni makane ken gbe na because mi ta we ne afe fresh ye ndwomi ona so inje wani Nuumo Okai eje wani aka chole papo chi ena jimo ni jesempe e papa mami ge papa ni court we prove no fe no court we lenche yue no fe no ona so min panye fai je min tabia ni come in fumi o min fumi e follow court we ke if you have a problem ya no challenge court we je min ni tete tabia ni min fe min defend Nuumo Okai at all cost dabi no ni yo wolu emi no ji no ni mi wie ni no ji no ni mene makane so bomoden kiyamoko ni lenwe kiyamoko boni afe ni wonye me ameka afe no ko ni mla mo ame if I cover fit away no like it go show like him show me may 35 per like why 70 no go so at least over 40 people like it go show me babu fight ami gonti no ni ya nwe eko onu ami gonti no ni ya nwe eko now introduction say ejeke because me ta ma certain name but na fake wa phobia ni working machine me ni tashi through the whole thing ko na menu shishi and Jamie care no na ni we be Jamie ni tete min care e ye wolu ani ni makane maabo ni oba anu shishimu nya waji anshi eshe all right so na screen no once again 2011 judgment nya waboti ami ni wakwa no ni eke cheme you find it kendo ko ni sanima le on the other side there nyani malia because boy me move away from the regular screen me can on the other screen so kendo ko ni if I nye text me if I show up eke inyena nya waji anshi cheme kanyeme all right so no jinoni ona ye ni no eke in the High Court of Justice Ghana held in Accra on Tuesday, the 4th day of November 2011, before His Lordship Honorable Justice K. Amisa Kunsin, on a suit number miscellaneous, I think that's for it, 1006/2002. Bona, kefie nomene, on a suit number. So 2002, Jibiamini AJK session. Nameji plaintiffs, ni ayi anang and 5 others. So the last name anang awo Korle Wulomo. Now there are variations. Clearly, of anake this anan is spelled with a G. Shike oba kome G ebejeme. So I don't know. Okay about anan yesempe. Well, no was spell all eneke me no am spell all eneke. Bepi ye gan Okai. Okay, mogo spell all OKINE. Mogo spell all OKAI. Fin Okai. We can go into so many names yaga ni was spelled all differently ni ekomi no na je shall I spell it differently moko spell or come with a K moko spell or come with a C I'm a family just sakumo chunshi. You understand what I'm saying? Moko spell or come with a K sakumo chunshi moko no spell or come with a C sakumo chunshi. So people will try to play games with bare spelling say can it be touch on it. Touch on it. Now let's go. Verses Egbert, Tetefio Annan, and 6 others. Judgment. This suit traveled back and forth through the hierarchy of the superior courts of the land before the commencement of the actual hearing. Court to me. Court to any name. The original writ of summons was filed on 9th May 2002 at 4 reliefs endorsed thereon. 2002 May 9 feni chemene keneken sanene te court to nibi ni ametawo ni court to aywe ha me no me ni bi edwepe. After directions had been taken on 31st October 2002, the endorsement was amended on 28th January 2003 to include 3 additional reliefs. Biamini after directions, Biamini court to a kwani ni echonake okay neke jiboni wo ba yale agbene amegani bi ete bafita edwe omo ni nomi amembi ni court to afe eha amen. Thus by the amended writ of summons, the statement of claim the plaintiffs claimed against the defendants are the following. No na mekani bi etene bafita edwe na efe ni bi pawe ni bi ni me ni kesane e ba ni bi ni amembi ake court to afe eha amen. Number 1, declaration that the purported nomination, election, and confinement of Papo Annan, the 7th defendant herein, as the next Korle Wulomo by the defendant is not in accordance with the custom and practice of the Onomroko Korle of Accra, and consequently is null and void and of no effect. Nibi ni me ni ketsanie once again but 2002 salene akete ashi Nuumo Okai ye Nuumo Okai kesane ete eko na kesane ete kotu eshile meni kete kotu nibi na membi akejeje eye ha me ne kenkle amegejeje ayue ake wache Nuumo Okai to ni atole ake Korle Wulomo echo kusumi mi na ke tole nibi ni ke ato Wulomo ye Korle we nibi na chomi kusumi nke ni femwe ni aketo Korle Wulomo na kan no me ni metole ame cho na kan ni bi emi no wa ko to akake eto na tole ejie follow ni esani akechuoni esani ko to afo eto emi ni echafo no na mekete eshi Nuumo Okai ni nya wo botiame. Number 2, an order prohibiting the defendants from going ahead to install the 7th defendant as the next Korle Wulomo of Nuumo Okai. Ake agbenenwe jeni court ba yue pe ake tonato Nuumo Okai acho kusum kegbejiano to papa na ke tole no wo court afomie she court wu asane kegbemene ni to Nuumo Okai na ake kejeke ya ameka tole Wulomo don ye Korle we. An order of perpetual injunction restraining the 7th defendant from holding himself out and or performing any function as the Korle Wulomo. Okay, kotu afa ni ekegbechi ni awo Nuumo Okai gbeno akele ekayano ni eche Korle Wulomo alo efe kusumi alo enyehe ake Korle Wulomo kula. Number 5, a declaration that the occupation and use by the defendants, especially the 7th defendant and their supporters of house number D403/2 or D477/2 Salaga Accra is illegal. Koto wasayano keke bechini Nuumo Okai no akeka che Wulomo ekayano nefe tumo Wulomo ne che Wulomo nefe kusum yake Wulomo koto ke bechini afueno ni koto afa ake shia ni ji Korle we ni Korle Wulomo hiyo le Nuumo Okai eshi na kan shia mi eka ba shia mi ndon e ya ke je Korle Wulomo ni. Number 6, an order for accounts by the defendants for the properties belonging to the plaintiffs in the said house appropriated by the defendants. Agbenenwe court afa ni le Nuumo Okai eba bu akunta ye shia na yin bia mi na ba yin shia mi eba bu akunta koni ni bi ni yo gen ke ni bi na efefe ye jeme ni ekenaka akunta bu aba. Number 7, an order ejecting the defendants and their supporters from the said house. Now court we akafa Nuumo Okai keke she me mo fe mo ni nye Nuumo Okai se ni amepiale court we afa na kan mehu ye shia ni ji Korle we shia ni wo fe wole ne yo sla onaga che Salaga market jeme court one femini e famo femo ni yo Nuumo Okai se. Now let's go on. Following the amendment, the plaintiffs on 30th February 2003 applied for a second direction in which they set down 3 more issues in addition to the former 5. So jejeke ni mofemo ke ni bi ni ametawo baba ni amechake ameni bi koma yin ke ba me ni kesane ne ba eshi Nuumo Okai ke we bi amesa amekani bi ekome bafitaye ekon ameni bi enumo na ameke ba kenkla amesa amekani bi ete bafitaye ekon ni jeje aye ehame. Again, perhaps in consequence of the amendments introduced by the defendants, and the plaintiff on 30th May applied for the 3rd time for new directions. These are set out. No say me no meka menike sande ba ka me no ba le Nuumo Okai ke we bi amo meka ni bi kome bagbe ama me ba chake ameni bi kome agie kome anya ka kome womi no mi no ewo me ni meka sande ba ama me dumo no ni ame apply for more things ame get jeje ka obasumo ni okwe ne ke ni bi na hu ka fitai mi ni bi ame ka me basumo ni jeje akwe ka fitai nya wo ya mi. Again, whether or not the first plaintiff is the acting head of family of the Korle Way of Accra, of which the rest of the plaintiffs are its principal elders. Wache nike saniete menike saniete ke ambasumo ni jeje akwemi ake anieji anukwale ake monike moni nye amenyi ameme na meke saniete moni nye amenyi na meke saniete anileji acting head be for be ane leji wokuicho because I work wokuicho about trouble about blam no one I used to acting head and not you banu shishi I work wokuicho no be leji money edumo wokuicho na jan ni me ni fite efe na make sane eba ameji principal elders ameji onukpai ni fita le wokuicho na make sane eba lo. B, whether or not the appointment of the first plaintiff as the acting head of family was solely for the purpose of overseeing the burial and funeral of the late Korle Wulomo. Ni keji lele ake leji acting head of Korle we ani tona atole pe ni eba kwe koni Korle Wulomo mo na choice ni di Nuumo Ayitey Cobblah the second Nuumo Ayitey Cobblah the second wanyamine leji Nuumo Ayitey Cobblah the second ani neke acting head ne ani atole ni le eba kwepe ake afun Nuumo Ayitey Cobblah ni jenyo ne choice ne lo. C, whether or not in the absence of the substantive Korle Wulomo, the gbese manche acts as Korle Wulomo. Ame smoni kote wakwe ni kote aywe ake ani keji Korle Wulomo be ani gbese manche jimoni kwese alo je gbese manche jimoni kwese. That is another thing now I introduce to Kebabiye. D, whether or not apart from the fourth and sixth defendants, the rest of the defendants hold any position in the Onomroko Korle. Achono kwake ameba sumoni jeje nwakwe ake ani meni amekesanie eba eshia me ani moniji edweno ke ekpa no ani nekegbe mene onukpa iji ame ye Korle we lo jeje ke ameke ambasumo ni jeje hu aywe nakaino ehame. E, whether or not by custom, the position of Korle Wulomo rotates between three families in the Onomroko Korle. Agbenenwa ameba sumo ni jeje akwe ni akwake ani lela ke Korle Wulomo bena wekui eten jimeni yo Korle Wulomo benalo nike ejebiye ibayabiye ke ejebiye ke tebiye ke ejebiye ke tebiye lo amega mbasumo ni jeje nwa kwe ake nakaino nakanjiboni eyolelo. F, whether or not the seventh defendant is customarily qualified to be installed as Korle Wulomo. Agbenenwe jeje akwe ake ye kusum niye alo ye kusum bena ani Nuumo Okai ni ameva amechole pakwe ani ya kusung bena esa ake eyo Korle Wulomo lo eyo Korle Wulomo ni eyo lo ya kusung bena lo. G, whether or not the election and installation of the Korle Wulomo is done by the acting head of the Onomroko Korle in consultation with the principal elders of the family, and if so, agbenenwe jeje akwake anika ba to Korle Wulomo moni dumo Korle Wulomo na jian ke Korle Wulomo be ani leji moni eke eche to Korle Wulomo lo ni keji na kaini whether or not the appointment or installation of the seven defendants by the defendants is sanctioned by custom ni keji na kaini ani toni atonumo kanye once again ani acho kusuming bena ni aketolelo. I, whether or not house number D408/2 or D477/2 Salaga Market, Accra, had been built long before the birth of Ni Tetekwe Molai, and if so, agbenenwe akwake ani shia ni yosla ani wa charge me ake Korle we shia na je shia agenyo se mi e ba chon kome aba wi efi oba na ani no amomo dani afọ wache Ni Tetekwe Molai lo wache Ni Tetekwe Molai oba no no e woni egbe e ba jemi ye bi na twi so pay more attention oba na aba che egbe egun oba na. J, and if so, J, whether or not the registration whether or not the registration of the said house in the name of the said Ni Tetekwe Molai was made merely for administrative convenience. Now, shia ni yo Korle we keji ote city council ni oyakwe moni gbe yo no di Ni Tetekwe Molai no abacho moni di Ni Tetekwe Molai na twi so ake sanje na mental na me court we aye alo ekwami na di ewie ji ake ani Ni Tetekwe Molai shia ama omo da na afole lo Nika ama shia dania fole be egbe ni ake register ni go the city council obana legbe ake egbe kano and ibenu just for administrative purpose lo can wolo ni bi fe mo e wo pe ni egbe yo shia no lo. Okay, whether or not the defendants have broken into rooms of the said house and unlawfully appropriated themselves properties belonging to the plaintiffs. Ani keji na kanwe ani Nuumo kanka e wonche amedwa chui kome ni amebote chui koma amli ni ama lo ni bi ni je amame no ni bi ni me ni kesani eba amame no ani Nuumo kanka e wonche amedwa shia na amete na ma lo na kan ni bi ke ha amehilo. L. Whether or not the defendants with assistance of high thugs are preventing the plaintiffs from entering the said house. Ani jeje akwe ni ekwake ani eji anukwale ake Nuumo kanka e wonche ama high thugs in this, you know what a thug is, right? Basa feloi ama high basa feloi ni amenchi amemena amekesane ne bagbe aka ameka ba Korle Wulomo. Now Nuumo Okai the defendant set down as many as 9 additional issues, all of which were struck out as taken care of by the issues set out by the plaintiffs. Nuumo Okai jeje ke only be na meta woni jeje awe ha me ni be kome nehu shinaka ni be fe jeje flofemi nyebu atwe jeje flofemi me no Nuumo Okai me jeje flo na kan ni be femi jeje flo na kan ni be femi because jeje keke kwe ni be ni Nuumo Okai me ta wona awe ha me no ni me ni me kesane eba eshi le Nuumo Okai kai wonche ni efe to the same thing keji anya answer na can question say anya awe na can question say e cover no ni Nuumo Okai me ke ba no jeje Nuumo Okai ma no e flo femi. Now channel it would appear from the record that prior to the settling of issues for trial, the defendants had moved from court to dismiss the action for lack of jurisdiction. So lele ncheke kwasani na ke sanene bia mi na ke jeshishi before na mo fe mo agree aka gbe na ba nya ye le Nuumo kanka e wonche amegete hey baba o na me ntaw na me yu ake court be e wale na yu Wulomo sane court be e wale na yu ni di Nuumo Okai ye le po e taw ni ne ke sanene no mi aka ye court le Nuumo Okai no mi e taw ne ke sanene e move from one court to the other even ya awo fe a chafon jeje ba kebo nya wo bu atwe any Nuumo Okai mekete aka shukwe aka ye Wulomo sandi ni jeje wu a chafon. Once again sanene ni kan yo habo in 2011 je Nuumo Okai ne ke nete no ni kan yo habo ne Nuumo Ayitey Cobblah A1B amemeni ya mesusu mo miye ato esa na to Nuumo Okai ama meke sani ete eshi Nuumo Okai. Now nya wo chano their main ground was that the nomination, election, and installation of the Korle Wulomo was a cause or matter affecting chieftaincy. Mino wa meke sani ete amegeka aye Wulomo sani etamo aye Manchester no ni wafe wali ake Manchester aye court aye traditional council, regional house of chiefs, national house of chiefs eke agbe na supreme court pe jimoni yo e wale ne eta Manchester sani no court BBF ameta Manchester no. Now mini jino na ke in his ruling delivered on 23rd July 2002, Asari Koran, Justice of the Appeal, sitting as an additional High Court judge, dismissed the application on the grounds that the Korle Wulomo was not a chief within the definition of the word as in the Chieftaincy Act 1970, Act 370. Kinkling on Amekete, High Court judge in Tano, actually Asari Koran, na can be a Leno appeals court to judge it. She ebatashi as High Court to judge. Ben le bona fiole to beni sometimes of justice is near Supreme Court be kuma me bata appeals court na me your Sunday as appellate judges before you understand. Like I know appeals court judges say I'm not bata Sunday no your High Court. So I chono gwa neke as a Quran appeals court judge ni she bata neke Sunday no as an additional judge. E wo Nuumo Okai ma Sunday e chafun. Me no e we chafun. a Chieftaincy Act 1970 Chieftaincy Act the way na a define manche Wulomo definition manche definition je komeni no amenya ameka ke anye aye Wulomo sandi ye court to moboni aye manche sandi ye court to. Now, dissatisfied with the ruling, the defendants, instead of appealing against same, resorted to yet another application to set aside the writ and series thereof on virtually the same grounds. Court judge Nuumo Okai many I won't get sani ne chafon. Ni ame no shishi ne sani ame appeal. Ame sama I won't no conclude keba. Ekong nakaino no na ame dumono na ame wokeba. Ame dumo the same ni no na ame dumo ake Wulomo sani etumo manche sani. Ne sani ayo e court. The inherent jurisdiction of the court were thrown out in for good measure. No na mekete awo fe na che no wafom. This second application was on 23 November 2002, again dismissed by Mrs. Agnes Dodgy Judge, as she then was as misconceived. Jejeke nyele che no ni nyekeba ni susun we ojugba ni nyewo nyekeba no ni nyewo keba ni susun e ojugba nya wacha no. Now, believing that their objections to the suit had been erroneously overruled, the defendants resorted to the Supreme Court for redress. Still, Nuumo Okai ma me no shishi. Ake still, court to eka me pangbe. Ake Wulomo sani esani ayoye court. Still, ame no shishi. No na me work at the Supreme Court ake Supreme Court aye ehame. Ake Wulomo sani esana ayo. In March 2003, they applied to the Supreme Court for an order of certiorari to quash the ruling of the High Court dated 23rd July 2002 as being null and void under its inherent jurisdiction, again to dismiss the suit for want of jurisdiction. I mean, no shishi. Now me work at the Supreme Court and I me file certiorari. Certiorari shishi peke diake court to agboe eba kwano ni court to BBUFA ni ekwake aneno ni court to BBUFA ehin alo ehin kehin eba we chafun no Nuumo Okai me ame file certiorari kete court to agboe ni Supreme Court aka Supreme Court akwe no ni court to BBUFA aka ni nkpakpa ni alo je ni nkpakpa ni ka je ni nkpakpa ni court to afemini ewo ni echafun mino ameke na kan ameke the same thing aka court to ebe egbe ni eta Wulomo sandi no. Once again, eventually this application too suffered a similar fate as those before it. It was dismissed on 17th March 2004 by Mrs. Cecilia Hansley Sowa J. Ekomeko na make say Supreme Court when no Supreme Court we chafo agenye ya se na me jinye ya se then you watch me feni na me yo ngo kan leche yo o kan leche ba fe gbe am ye na me jinye ya se then you watch me feni ngmenye yo kwa me da kokoi ko to eke kwa me da kokoi nye ya se when you watch me feni no me ngmenye yo. Yeah, say, Benyele, yeah, say, Benyele, yeah, say. No me eyishi ile no na eyi no. Nya wacha no. Let's go. On the 16th of June 2003, the issues for trial were finally settled in the summons for directions. The court notes for the day as recorded read. The issues as raised by the summons for defendants filed by the plaintiffs take care of all the additional issues. Issues 6 and 7 were raised in preliminary argument and had already been determined by this court. The court therefore will not set down these same issues for determination. The additional issues are not necessary. The issues set down by the plaintiffs will be the issues for trial. The additional issues are hereby struck up. No, on June 16th, 2003, court tashi ni nubi fe ni esani akwe alo abadomono ni akaye sani akwe na abu afena issue 6 and 7 ni arezi biamini aywe na kani bi court weke no mi le court e decide ye no mo no ekenoko efita ekodo na abacha no ni bi ni ameme na mege sani ete eshi Nuumo Okai ni bi na ameke ba court weke no jino ni wo ba kwe no ni wo ba ye sane nya wa ya no. Although the record shows the defendants appealed to the Court of Appeal on 27 June 2003 against the decisions to strike out the additional issues, there is no information on record that appeal was pursued. Can you back in earlier? JJ nibi ni Nuumo Okai make ba bi amina abote ni bi amina me abi directions can be fina get me nibi na make ba aka ye ha me JJ na can no floor fame because ke kwani bi ni Nuumo Okai make ba so to ikobenomli kani bi ni me ni kesane eteke ba so ateko benomi kana kan no mi no woni jeje for fame here jeje ke ni e flo fame here Nuumo Okai ma me sa me kete appeal court koni judge conclude atano ni usually ka te appeal court about three judges ni tano ni ametano ni ame yu ake esa ni judge here flo ene umi shi ke jeje ke na ekwe na kan sane Nuumo Okai ma ama di se don no baba cha no na ye sane amo. The above is by way of appreciating the background of the case and the rough terrain this suit has traversed up to the opening of the trial proper on 6th July 2004. So in me fe koni bomoni o kaneneke no kone alo tumoboni o kwami no bomini tete tuene koni onna ni bia me ni sane etwon dani eba shebie ni wo ba tami ni wo ye ne ke ekebo ene me fe kono na ke sane ne ke 2002 na ba jenhie 6 July 2004 jibi amini abua ni bi na efe na ni agbene afe ready ni abaye. Now mini you know ni jeje iwe ke shashi I will at this stage state the relevant facts as pleaded by the parties. No jeje ke agbene eni she ni bi ni meye nyone na meke sane ba aken tami ni yue ni bi na me tawo ni ma yue agbene mkefe ba hweshi koni me ana. Now according to the plaintiffs, the first plaintiff is the acting head of the Onomrako Korle, and the other plaintiffs are principal elders of the same family. Jejeke, meni kesanene ba, moni nyame ye, kinkle moni nyame ye, leji moni dumo Korle we icho najiam, because abe Korle we icho, according to them, abak blam ya chombo. Ni meni be fite efe na mekene kesanene ba, eshi Nuumo Okai me, wonche, ne ka mi chuoni, jino. They admit in their pleadings the defendants are also members of the family but hold no positions. Kaja bi eto na mesani eboing be. Nye bu atoe. Many kesani ameke o. Money nye wanyi ni plaintiff number 1. Mo kenkeni nye wanyi leji money edumo Korle we icho na jan. Ni meni me fite wa meni wo fite efe Korle we onukpa ijiwo. Ni wo fita ni ke acting head ne ni wo ketwoni. Ameno amekake me kwa meni ameke sane eba ishie amefe ameje Korle we. But they admit in their pleadings that defendants are also members of the family. Ni chwaga meni ameke sane eba ishie amefe ameje Korle we but hold no positions. Ameje Korle we shimon ame je Korle we onukpa iji ame. So nye kwa no na ame yue agbene nya wa ya hie we nya kolege ko male kenklen obamale unkatana no ko ya no kwale yue mo shishidi yue mo anu kwale gunglo nye kwa no na me yue bie nkenye ba na. Following the death of Nuumo Ayitey Cobblah II in 1995, the traditional office of Korle Wulomo, which plaintiffs contend but takes between 3 families in the Onomrako Korle, became vacant. Amekemini meniga sani aba amekemini amekeni ni Nuumo Ayitey Cobblah ni jenyo egbo ye afi akpe o ai neun kenyuma neun ke numo bia mniye Korle Wulomo bena ebakashi. By custom, the nomination, election, and installation of Korle Wulomo is done at a meeting summoned for the purpose by the family head and attended by all family elders. Amegeya kusung bena keji abato Korle Wulomo moni abafa ke moni abafolemu ke moni abakpagbe akeleji moni esane ye Korle Wulomo onupa ni yo hia na ka onupa le fan onupa ife ni yo Korle we na tashi na akpeo ke akpe e ka mechu na kanu chumo. The plaintiffs allege that contrary to the accepted customary practice, the defendants, without the knowledge and consent of the plaintiffs, quietly and surreptitiously nominated elected and confined the 7th defendant in preparation for his installment as the next Korle Wulomo to succeed Nuumo Ayitey Cobblah II. Ameke boni kusumi e yole ne sanafi. Ame tasino bena mana ne kegbe mene na me ame yue aka me nyeme je ame no na me Korle we. Ame di nche ama fe du anshi ni bi ni ame fe temo mi ni bi surreptitiously surreptitiously be o fe no ko ye temo mi no ko no sumo ni me na bona no ama fe temo mi ni ame select ni ame nominate na ame was 7 different energy Nuumo Okai ni ame tole Korle Wulomo ne ba ye Nuumo Ayitey Cobblah ni jienu na jian gbeno na se na ame chon ni ache meeting na tashi ni weku fe akpene ake money woke ba ya ne ame fe na kan ame chodu jiami ni na ame fe ni ye temo mi be na ana no ame mo Nuumo Okai ama wole tumi aka me ba tole Korle Wulomo nya wa chano. The plaintiff contended 7 defendant is not customarily qualified for that position by reason of not being a member of any eligible families. Ameke Nuumo Okai ye kusung bena esa na tole Korle Wulomo e begbena e begbena yo Korle Wulomo e jake ka me ko ehihie weku ete na me ka yo Korle Wulomo ke jomi le Nuumo Okai ne ke weku ne eje ekokura ami no wa esa ni atole Korle Wulomo acho dun shishi na fio ni bi kenteme na ba atole Korle Wulomo. They further contend that house number D408/2 or D477/2 Salaga Market, Accra, was built by the plaintiffs as the family house of the Nomrako Korlewe, where a lawfully elected Korle Wulomo and his family reside. Ametero na me yake nekishia ni yoslane ama boni afe ni Korlewe ke ameto Wulomo ni Wulomo ke wekume abayi na kanshia mi. Defendants have unlawfully occupied the said house, broken into the rooms, and unlawfully appropriated properties of the plaintiffs, and with the assistance of higher facts prevented the plaintiffs access to the house. Shimon Nuumo Okai ye wonchene ame dwake bashia ni ame dwadwai chuine sana ame dwo ame te ame lolo ni bi ne sana ame lo ni ame ke gbeme fonji me ni me fi oni fon gbeme ni fi oni fon e badumo Korlewe ni achi ame gbe aka me ame mo na ame je hia me ame me na ame ke sane ba na ame chi hia ame je hia me ame mo ame mba achi ame gba ke ame be no ko klomo e Korlewe ne sani ame ba je me. Now, on the part of the defendants, they all claim to hold positions in the family, either as office holders or principal members. They deny that the Korle Wulomo rotates among 3 families. Now, Nuumo Okai won chair, mini journal ameke. Amefe Korlewe bi jiami. Ni ameje Korlewe ni ame yo nu pa ye Korlewe. Alo ka me ye Korle wo nu pade enche gbe me wujinji ame ejeme ameke mini keji me ni kesane ne ba ameke Korle Wulomo gbena ayo ye hyian eten mi ame male aye ye hyian etemli Korle Wulomo gbena aye ye hyian etemli. Now, as far as the defendants are concerned, the first plaintiff at some time acted as head of family for the sole purpose of supervising the burial and funeral of Nuumo Ayitey Cobblah II. Ameke meni kesane ne be issue wone moni di kenkan ne nyame ye waje woni ake ye be ko ne we watole ake e ba fe we ku onupa si watole ake ba fe we ku onupa ko ni e ba kwe ni afu Nuumo Ayitey Cobblah ni je nyon no pay watole waka no go fitai. They further pleaded that by custom and tradition the gbese manche acts as Korle Wulomo in the absence of a substantive Korle Wulomo. Ameke keji Korle Wulomo be gbese manche jimoni edumo Korle Wulomo na jian le jimoni echuo Korle Wulomo nuchumo kata biami ni abato Korle Wulomo konklu. If you don't know something, you've learned something. So gbese manche ye gamanche sepe ko ke Korle Wulomo be gbese manche le no jimoni e ke gamanche be bese manchaji moni efi ogamanche kusumi nke ni bi ne dumo gamanche na jian na kan no ke Korle Wulomo be bese manche le no ke Korle Wulomo be e ba dumo Korle Wulomo na jian ne ba chu Korle Wulomo kusumi ka tabia mi na ba to Korle Wulomo konklo je mi nke ayawo wo loko ke ba 1930 noko ni angmaye ni nye ba na fin now in respect to the 7 defendants, they pleaded that his nomination, election, and confinement were all done in accordance with custom and practice. Ameteno na me yake Nuumo Okai toni watole wacho kusungbe no kegbejiano toni cheme ka funshi akeka to Wulomo achono na aketo na kegbejiano no wacho ni aketole. Responding to House number D408/2, the defendants denied plaintiff's assertion and averred it has always been in the name of Nitete Kwe-Molai, grandfather of the second defendant. Nibi ni plaintiff say me nigga sande na amen ya ekomeni yo amen jake ani jeje akwami ni ake ani shia ni yo sla ama blame omo dani afọ wache Nitete Kwe-Molai lo ni egbe ni yo shiano ake ele shianie ani na kan no eye no ke awo jiani fe mo keke peni lo kanye ba kai na membi meneme uncho no gwake shiana ma isla it has always kaja obuade as far as they know what Nitete Kwe-Molai ye legbe jimoni yo shiano na moji what Nitete Kwe-Molai me pao ji meni akesane te eshi enyo no ni yo miye ameka na ka enyo no le papa a grandfather eni ji wache Nitete Kwe-Molai the second defendant papa eni ji wache Nitete Kwe-Molai now you now anytime no know the 7 defendant Nuumo Okai legit the 7 defendant me power na kete Nuumo Okai legit number 7. Now the first plaintiff testified on 6 July 2004 as pleaded. He claimed to be the head of family of Nuumo Okai and the other plaintiffs holding positions in the family. He admitted to knowing the first to 6 defendants, but denied they hold any positions in the family. Moninye Chamena Yena Mekasani ate ni the first plaintiff ni le no acting head of family according to Ame. Eke leji wekuicho yona makokolewe kemeni fite he fe na Mekasani ba eshi Nuumo Okai men. Now, here wo miyake me na Mekasani ba eshi ne keje mokenkle no ke ata moniji ekpa no ele amefe shikeji ne ke gbemene ameke ame yo gbenako alo ame ye gbenako ye Korle we ame male ele ame she ame be gbenako ye Korle we. Now he stated that the 7th defendant was not a member of the family and that he 7th defendant comes from Sepe ekeshimon papa le na chole Nuumo Okai ne ba fita ine me yekpa nle ame fe she ame ye gbena ye Korle we mind you me yekpa ni yo mi Nuumo Okai e papa fita me yekpa e papa ji defendant number 1 ona nke call you mo nke sanene call kan yona mind you Nuumo Okai defendant say e papa ji defendant number 1 papa ne nye ma yana de sane ete e ke je Nuumo Okai papa no ke atamo ni ji ekpa no ele amefe mind you she je mi ame ke je ji ake amele me fe aka me je Korle we bo ka ya ke nkan ya bo amele amefe aka me je Korle we agbene ne ba ke ele number 1 to number 6 first to 6 defendant first defendant Nuumo Okai papa di first defendant ekelele Simon number 7 ani di Nuumo Okai le je sempe ona any case ebo apart fall mo ye chemega nyame ona any first am a case ebo fall mo ye Bana. Shout outs to you, Nyaye, to your team. Ona. Bana. Ona any am a case a boy a boy fall in my party here. If you're there no leomoche, no lemoche, ake eje Korle shoke bile olele she bile je sempe. Nya wachan. On the custom for the appointment of a successor Wulomo, he testified that he, as the head of family, convenes a meeting of the heads of family to select a successor. Ekekeji aba Korle Wulomo to le niji wekuichu Korle Wulomo le sane cheme ni etashi ni na kan selection amefe. The defendants, not being elders, are not eligible to be invited to such a meeting to consider the selection of a Wulomo. Ni me ni wakasane ne be shi ame ni ame je onupa je ame Korle we na kan meeting na kan pe keji wo che esani ameta mi yeko. They are also not entitled to select a successor Wulomo. Ame be ewaleun ni ame ba chon moni ba ye Wulomo. According to him, a successor or Wulomo must trace his lineage patrilineally and must of necessity come from Korle we. Amegena ke arawo boko ni mo aye Korle Wulomo na ke mo esani echese je Korle we ke echese eje Korle we be na ke mo esani eyo Korle Wulomo. The plaintiffs denied that the Gbesemanche acts in the absence of Korle Wulomo. Amegemi when yemene tabie na ameke ke Korle Wulomo be Gbesemanche jimoni kwese ame male ke Korle Wulomo be je Gbesemanche jimoni kwese. Although they admit there was a dispute between the Gbesemanche and the Korle we, they dispute the defendant's assertion that the dispute was resolved and the Gbesemanche resumed his role as acting Korle Wulomo. Ameye wo mi moake neke biamini neke tone ya no saneko yeah between Gbesemanche at the time ke Korle wekue shimon atashi ni ayue keji mene meka atashi na ayu amemale na kensane atakoshi ayueko. The plaintiff contend that it is not a tradition that the kingmakers appoint the Wulomo and that it is not true the Wulomo is put on the lap of the Jaseche. Amegena keji ake Jasefoye ni amame to Wulomo amale Korle we abe Jasefoye ni to Wulomo ni keji akeka to Wulomo akeleta Jaseche shuono shieten na keno lewe je anukwale ni menike sani ete yuoi. According to the plaintiffs, the sanction of the installation of the Wulomo by the Sakumo, Nae Wulomo, and Gbesemanche is not customary. And if they did so in the case of the 7th defendant, then it was done out of ignorance. Amegana ke ato Korle Wulomo ka che Sakumo Wulomo ache Nae Wulomo ache Gbesemanche ni ameka ame ba womi ni ame sanction na gani femo na ame chuchu ni bi kome na gano ame susumo mi ebe kusumi no wakeji meneme ato Nuumo Okai ni ame chu na kan no be ame chu no ni amele. On the existence of the two traditional officers of Jaseche and Agbache, the plaintiffs dispute that they exist in Korle we or that the defendants hold those positions. Agbenenwe noko wona akwaji wache Nuumo Okai ke we bi ameke ya Korle we ayenoko na achole Jaseche ni ayenoko na achole Agbache ni ke eba Korle Wulomo to mi amechuo ni bi kome wacha mene ni kesane eteshi Nuumo Okai me ameke na keji Nuumo Okai me ke ayenoko na achole Jaseche ke Agbache ya Korle we no na me yu ame male amele ni keji na kenoko ye poe chemene ni fita Nuumo Okai ye na me ka keshi amete mokomi Jaseche ni amete mokomi Agbache ni because amechemeye ni amo ba me ya me chena jian no na me yu ame male wole amete moko ame enyone na me talabie wole amete moko ake amete mokomi Jaseche ni na amete mokomi Agbache ni. Regarding house number D408/2 or D477/2, the plaintiffs contend that it is the Onomroko family house built by Odai Into. They contend that there are two houses on Onomroko Way and Korle Way in the same area. Negeshian enyone bia ne hia enyosan ya yo. Amenchono kwake Moni machine achole odai into leji moni machine ni negation enyone ne mane acho ekome onomroko we ni acho ekome Korle we fe ye the same area, the same stretch. According to the first plaintiff, the three heads who elect the Wulomo are to occupy the house. They, the plaintiffs, are virtually being chased out of the house by the defendant. Ameke negesia ine enyone ni ya moni amelene ma na aka cholo dai into e machine enyone boni afe ni moni ba ye Korle Wulomo ke ewekume ame negesia na mi shiame ni amame yo ni Nuumo Okai eja me na sempe amemo ahwame ye shiami ni amame ba koshia. Plaintiffs deny that the house has ever been in the name of Tetekwemo Olai as claimed by the defendants. Ame tena na me ka ke na wanye me ni telashe ke ya me ke shia na ma Tetekwemo Olai be mi ame male shia moni ma acholo da into e be Tetekwemo Olai be mi. The fourth plaintiff testified. The fourth plaintiff that he knew the defendants and that they hail from Sempe and not Onomrokowi. Again, many metalashi na wale ame shimo ameje Sempe Onomroko we ameje. Now, according to him, the first defendant's father, Okai Anan, who became the secretary in Korle, hailed from Sempe. Again, in Kabaka first defendant, le Nuumo Okai, a papa the first defendant. So, fourth plaintiff ne, again, but Nuumo Okai niye le eja Sempe, she by a secretary can Korle Wulomo. Wale ni, le Nuumo Okai wale ni, enim by a secretary can Korle we. Bona, e by a secretary can Korle we. She wale ake Sempe GNJ. He also denied the existence of kingmaker at Korle. Negana kake ayeme jasefo ye Korle miele ndiaga jasefo ye Korle. He however considered that the first plaintiff and he did not take part in the installation of Nuumo Ayitey Cobblah II. Ni wo miake biamina to Nuumo Ayitey Cobblah ni je nyono ame begin like a first plaintiff like a Monique woku ichojile ye neke sanede mi ame begin ni ame ka me wo mi. Now, the first and third defendants testified on behalf of the defendants. In Kabwake, the first defendant leji Nuumo Okai e papa leji first defendant. Moniji eteno ye ame group mi amame yo dase ke me ni akesani ba eshi ame fe. Now, they contended that in Korle there is no head of family, and that it is the Wulomo who occupies that office. And again, Korle wabe position kona chole woku icho e. Ke Wulomo tashiye. Wulomo leji Korle fe woku icho. First defendant testified to his parental background and the positions of the other defendants as follows. Nuumo Okai ni the first defendant. Eba tashi ne blami ne chole shishi. Ke menifite fe ame shishi. Any amenyemeje, any amechemeje, can you be fair? Nya wabuatwe. Meji Nuumo Okai papa ke. Again, my father called Judgement. Dabi, the whistle. Nakano, ayue fe, jame. Where say no fe ayue? Ina, well, about me. It was Sunday by jame. Near me, Nakai. So where say no? Come like a near me. Apele ake the other one you know na chon allo energy no na chon match again obana. Yep. So again my father called Judge Okai Anan hails from Korle. Again me iche na chole Judge Okai Anan eje Korle. Second defendant is my father's brother's son cousin. Modi nyono ni if fita in here. Papa nyeminu ebini no cousin. He hails from Korle and is the Korle Jaseche. The third defendant is from Korle and is the Korle Agbache. The same word obana aywe jame word say nyo apele call to ake ani Agbache ayu alo agbafo ache The fourth defendant is the Korle Wulomo. Money je John ne fit awoye. Korle Wulomo. Fifth defendant is the Nuumo Wulomo. Hey, grandpa, Nuumo gba me. Oh, Nini, ona, Nini, Sano Saga, Dani Achebo. Nini, Ming Pofai. He came in Pofai, Nini, Samo Gandana Achebo. Hey, Sunny Efe, go, Hemi. Oh, grandpa. Yeah, what channel? Ofane Jani Femo, Kaleche, Toyote, Kiamoko, Nilewe Kiamoko, Ye Shibami, Jani Femo, Kiamoko, Nilewe Kiamoko, Nilewe Kiamoko, Nilewe Kiamoko, Bomode, platform Sano, no, your fan, can make Jammy fan, Jacket by fan, let's go. So, Mleche Nini, Nuumo Wulomo, like fifth defendant, if it Nuumo Okai. Sixth defendant, Monifita me ni je pa no, Leon Wayoni, ye Korle. And the seventh defendant is his son. Niji Nuumo Okai, Niji number 7 le ebini. First defendant's mother, agbe nye buatwe, any pakpo eje, nye buatwe, game, nye buatwe, any pakpo eje, nye bua, any pakpo eje, twe. Inge, awulawe, nije ye kpoe, awo na achiche. Shini for imma ina na kanso agbe na achiche nge won bi yoe no kaji na achiche ye no go come ya wulawe abake because imma gbe ni nke wole ewo esa na eyiyo nye buatwe. First defendant's mother niji Nuumo Okai e papa e mami Hana Aku Alote Brown hails from Sempe. So Nuumo Okai papa eje one ege me inye eje Sempe atole Hana Aku Alote Brown eje Sempe. First defendant has 2 brothers. Shimo me iye menyo. Acho mokome Christian aya mensa anang ni mokome achole Edmond Adu anang, and their names evidence in their origins as coming from Korle Wulomo. Yeah, in the cake bay na menyene aya mensa anang ke adu anane ka ke be chon ke ene Korle Wulomo bayni adu anang ka ya mensa anang chon ke Korle Wulomo bayni ke jemi ke le na wo Korle Wulomo ke. He tendered exhibits 1A, 1B, his personal baptismal certificate, and those of his brothers bearing the names of his parents to prove that he is from Korle Wulomo. Ni eglami neke akele enyeje Korle Wulomo ni enyeme yenyo mokomi achole Christian aya mensa anang mokomi achole Edmond Adu anang eyue keke Shimon ame birth certificate ame baptismal certificate benye le chuchu ka solebu abo certificate ino inye no lo ebiye ekeba nini jeje ke ni nkwa no lele mi na ke be ni ame ma na ka no ame solemo certificate na afo ame na sole ame certificate na ha ame be ni ekeba pepe ni. Now, other children of the first defendant are Nuumo Okai and Nuumo Adu. Nuumo Okai e papa no e bi conclame acho mo come Nuumo Okai acho mo come Nuumo Adu. The seventh defendant son of the first defendant bears the name Pakpo, a name admittedly not from Korle Wulomo. Now, ebi niji Nuumo Okai eje woni ege yes imbila achole Pakpo. ni pako awo pako ye Korle we eliaka wo pako ye sempe. Now, first defendant, however, explained that the name Pako was borrowed at the request of his mother, and the necessary customary rites were performed to evidence that effect. Again, me. Lele, ije wani. Ibila chole Pako. Shimon, me, imami. Jimoni bi aka esumo ne nabile mi mami ne jesempie le jimoni bi nje wani imami jesempe acho mami ana aku alote brown ije wani imami esempe yoni she mami eni inform bi imbile le ne request ne fa ne pamify e can be min sumo kanu jimie gbe ni ma wone ne wa min sumo ni obile no for ni obole ne ke gbe ne ehami eje wani ake awo Pako e Korle we egelele awo Pako e sempe enyeje sempe she mami ni pafai ake esumo ni ake we bile nke ambo example nke nyeti ame pie nye fe pi mi na kansua leji na achiche achole na achiche kwa mma na le gengbe imami le peji mo na banale mami ke mi ake na ekemi yoju gba esumo nsane. And I've told this story. Some of you that are very personal to me. I've told you this story about how ni nyama digress at 2 minutes about how ni in wombile na achiche. Inyemi onukpa. Ebi 5. Ebi even hinson. Miunima from firstborn ni vanu. No itegana. Ni no mi ina ayo boko. Ni anale choko. Ni ngele tashi. I don't remember the exact conversation. Boni conversation she nkela ke ona eyen paye hami. She ke info yo enkele ba wole mami. She be na ke nyami onupa hinson efo. Miuni mafo mfonu. I'm picturing my grandma and I having that conversation. Ya choko min ngenye yo na picture. No nege hallelujah. Awo chiche. Bona no nken na ke soliami. Lele Benin Jogana mba boli in lucky from ball and in will go. Lele uni manyaba for ne for you. No she won't get Hannah. I can solely hammy for I know Yemen your call in Kenya you ain't tronye because in Jawona again. She won't get Hannah. I can solely hammy for you. Mawo e mami iyena can she weno. No ya wulawe. Kaji na achiche ye no kokomo ya wulawe abagen wole na achiche no eje ndon ya wachano. The third defendant testified that the third plaintiff was his brother from the same father. Agbene nyebu atwe nke kono ke afeni na eyin gbomon na we kunyo no egalele. Mini sanene. Mina fio. Nyebu abi ene etwe. Nyebu abi etwe. Nyano. Nyebu abi etwe. The third defendant, nyebu atwe, testified that the third plaintiff was his brother from the same mother. So modijiete ne fita Nuumo Okai ye. Eyo dasi ake modijiete ne fita meni ke sane ne eba ni wo yone. Inyemi ni wo fe che kome wo fe che kome le wo. Now, according to him, the second defendant is his cousin. Their fathers being brothers, and that he, the third defendant, holds the office of Agbache. The fourth defendant, who is the fetish priestess of Korle, is his senior brother's daughter. He corroborated the fact that the fifth defendant is the Nuumo Wulomo. Wekume son. Now a channel. Of the witnesses who testified in this trial, Only the third defendant gave a detailed account concerning the custom and practice pertaining to the nomination, election, and installation of a Wulomo. Many by your dase san name fe defender ni jete no ne legiboni ejegbe yo daso do ba na cho kusumi nkegbejiano to no na chon ni aketo Wulomo. He testified that in the absence of a Wulomo, the Gbesemanche acts as such and would, in the event of vacancies in the Jaseche and Agbacha position, request the appropriate houses, i.e. the children of those office holders, to appoint replacements and then consult to appoint a Wulomo. Keji abato keji Korle Wulomo be Gbesemanche jimoni edumo enajan ni keji abato Korle Wulomo eba fa ne keja sechene kenega Agbacha ni amefitei ni keji ne ka Agbacha keja sechene ekobe efa ewekume ai ebi ni amechome ni baye neke positions ne najan kona batashi ni afepe koni moni esani awole. This initial procedure was followed in the appointment of the hearing seventh defendant. Neke bejiano tone wachono pepepe ni waketo Nuumo Okai. After the children have made appointments to fill the Agbacha and Jaseche positions, they informed the Gbesemanche to come and perform the necessary customary rites. These procedures were followed in the instant case. Yoda se ne kake keji be ne ameba ko ame chema positions ai Agbacha ke Jaseche ameba wo Gbesemanche to no eke Gbesemanche ba eke fitame eke kusumi ne sani afe ni aketo Wulomo keka afe na ken kusumi eke aketo Wulomo. After these customary rites, the Agbacha and Jaseche sit together with the fetish priestess, and an oracle is consulted to tell them who to be appointed Wulomo. Ekekeji Gbesemanche amanye ni atashi ni afeni agbene keka atejema won keka bi jema won keka jema won echon moni esani atole Wulomo. After the oracle has given the necessary directions as to where to choose the next Wulomo, money and drinks are sent to the Sakuma Wulomo, Nae Wulomo, to inform them that a Wulomo will be installed within a week. Keji ache jemawo ni jemawo chon bejiano to ni acho ke money acho money afa ni abatole Wulomo keke akeshika kedan ete Sakuma Wulomo ngo keke akekwete Nae Wulomo ngo keke ayake amake abato Korle Wulomo ye ochimami. This is to get them to hold themselves in readiness to perform their customary duties at the installation. They then select 6 to 10 strong men to go and capture the chosen Wulomo. No say me akadaka Wulomo ya koni amesami ake amesami ake abanaba wo Korle Wulomo. No say me aseletio alo afamo hinkakaloi ekpa ke ashinyuma ni ame ya walo jogba ni ame ya ni amamo moni akeni na efo no ake leji moni abatole Wulomo. After the capture, some special leaves are put around its neck with shouts of Neo, Neo, amidst pomp and pageantry. Ke afe na kanye ke you see ye tia me pie nyele ni because nyana kona to manchena so nyele ni wa posti min digress bibio ni wa posti gamanche ni adamalache ewo mo mi na telele na kele mfoshie ke vie de mogo baga me kwa mini nyefia enenwe ya kusumi enenwe kusuni ke ato gamanche mini ateli ole na kele pa ife nye leni nye kase ni Wulomo po awole na kele pashi nye kase ni kenye baba nye dad nye lero kono nye sha alu nye lulu menta international. When the Wulomo is brought to the house, a goat is slaughtered and its blood poured on his feet. Ke ama Wulomo ni mofemo akele bonshi mofemo bonyamo ni na akele bashia mi agbena foto ka foto e afoto e ake la eshwe enani. He is then confined in a room to be with the fetish priestess. Akalaba wochumi keke eke waye na kenchuemi be achonle kusumi abacha no. Now, on the day of the capture and confinement of the Wulomo, word is sent to the Gbese Manche. Keji amo Wulomo akayuemo ya ne akaha Gbese Manche na e Wulomo ke sakumo Wulomo, who also sent emissaries to come and ascertain the information for themselves. Ne kegbe mene ka wa mehiem amamba chume keba ni me abakwa ka anelele ake awo Korle Wulomo chumilo. Around 10 p.m. in the night, the Naya Wulomo and Sakuma Wulomo would come to the house to see the chosen Wulomo and teach him the do's and don'ts of the office and leave around 2 a.m. Keji awa machine kama ke no na fene ka twa gbeke mejinyuma amebaba the Naya Wulomo ke Sakuma Wulomo amebaba na amebaba te tuemi ni Korle Wulomo ni awole tuemi ameba chole gbejiano to boni esane famu energy nibi ne esane fake nibi ne esane efio noni esane boni esane ekule alo enye ake Wulomo ameba chole gatwa gbekete ameba ni ameba chole na kanibi efe na ameba shi around manke mejienyo. This ritual continues for 3 days. Neke kusu ne afiole bi ete. On the 3rd day, the Wulomo is dressed in white calico. The Agbache sits him on the lap of the Jaseche 3 times, and the Jaseche in turn sits him on the Korle stool 3 times. Ke agbena biete na agbena le Wulomo ne abawole eyen futa abawole klala yen ka wole klala ye Agbache kele bata Jaseche shuono shiete eke ke agbena kele Jaseche le wenfoe eke ke Wulomo na toe eke ke le wen eta Korle Wulomo seno shiete. After this, the Gbese Manche will come and greet or congratulate him, followed by the Sakuma Wulomo and all the Wulome and chiefs assembled. Finally, he is given a stool name. Ke agbenona le Gbese Manche ebaba keke ebahale otrinkwa te wakole gaminte. Ege ebahale otrinkwa ege ngale eke Wulome konklome ni baba ke majiache me konklome ni baba fe amefi ame bahale otrinkwa eke amengale eke agbene ahale singbe nyecho amie otrinkwa ta kole gaminte nike ina ejeme nka yu otrinkwa don amebala ayeko. Thank you ayeko. Thank you. Hey, Okaleche Obesuba. Okaleche, do they teach him about AI? Okaleche throw bomb way. Okaleche, behave. Okaleche, behave. Okaleche, behave. Oh my goodness. Come me continue. I'm continue. Johnny Femo, Kiamogo go do. Me Babu 5. Now, to my wedding care when 2011, no, one way or baba, no, I realized last weekend, no, baba war. So one way, so no baby, no care me. Come on, me, I can't never need the TV. One you are quality. No need your call to me. One trouble. Ogaleje. Yeah, she buy me. I been my catcher man. I get AI training afitai. Onu. My catcher man. Where information technology be honest. So kage AI fita Wulomo yeli it's not bad. Oh Charlie, I got watch you. I go aye. Third defendant testified on oath that he lived with the last Wulomo in the Onomrokowe house for over 30 years. Mene moniji wachaniji etene bele le niji agbachene. Eke le eke Nuumo Ayitey Cobblah niji enyo. Niji enyo ekele yin Onomrokowe ne ekele yin jen fe afi nyumai eten. His father le eche tetekwe le eye agbache ni le eche tetekwe le jimonito Nuumo Ayitey Cobblah niji enyo. Wulomo ne choice ni abada ni abato enene le echeji agbache ne to Nuumo Ayitey Cobblah ni jenyo dani le bia ne eba ko eche position ne Let's go on. The witness testified that Nuumo Ayitey Cobblah was put on the laps of the then Jaseche, James Ashon Ayitey, the father of the second defendant. Come on. Me. Ipapa, ne to Nuumo Ayitey Cobblah ni jenyo. Ekele ta Jaseche ni yo jame at the time. Actually, James Ashon Ayitey. Ekele ta shua no shiete. James, only no ayilo. Okay. Ben again. I hope I can tell you about only no ayilo. Only no ayilo. Thank you. Only no ayilo. Thank you. Right. So what do you have it? Yes. Ayitey, the father, he testified to how he and the second defendant were appointed Agbache and Jaseche respectively by their families. Akani amecheme eye neke benane wo ameu awane ni amebaye neke benane. Now, the significance of the testimony of the third defendant is that the seventh defendant is customarily qualified to be appointed a Korle Wulomo, and that all the customary rights and practices pertaining to his nomination, election, confinement, and installation were duly performed. Third defendant ni je tenone le kometo edasene bahaya court we ene le ake lele ake Nuumo Okai acho kusum beno na acho na ake fale ni afolemu ni amole ni akeleto ni achosele then ya fele Korle Wulomo je ke. Thank you. Aga yeko is well done. So it's different from onine no ayilo no jibe. Congratulations. Onine no ayilo. Okay. So again, kebo ebo wachane to ni ji agbachane ebo le to the way ne bla kusu emi ke gbeno na mecho ena ke odabi Nuumo Okai be atole ojogbang. Now, in respect of house number D4H/2, third defendant stated that it belonged to his grandfather. Ni tete kwe molai. Neke wachene no ekena. Shiana acho ayuos and me ni tete kwe molai. Le shiani. It was in that house that his father and aunts were all born and lived. Neke shiamie no ni me. Afo minche. Eni machine eni tete kwe molai. Neke shiamie no na afo minche ke nyeme ke enofeno. According to him, second and third defendants were all born in the house. His brothers Ayitey and Aya, sisters Tete and Tetele were all born in that house. The third defendant further testified that by custom, the deceased are laid in state in their paternal house, and in accordance with the custom, the following close relations were laid in state in the house. To bobeno lie ko gbo o chesa ka bofon e ke nakan ni nakan gbena anwe nakan no afe tete kwe mo like mini better defendant there you are eni na chole tete kwe mo like na egbo jame akelengme e auntie na chole kokoi na egbo 1959 jame akelengme enyemi tete Messi na egbo jame akelengme le enyemi aya akwe na egbo jame akelengme le obolo akwa fourth defendant and daughter leun jameji eni akelengme ebi a fourth defendant in your case in leun jamenoji eni akelengme. Now, from the evidence, let the following facts stand undisputed. No fe no ni botwe so far ni third defendant ne eba yue ni BFA kem buana negeji boni mamole ni magbe na ake anukwale ni yo sandi emi fe ne Nuumo again ni shi Nuumo ni Nuumo Ayitey Cobblah the second was the last Korle Wulomo leleng ake Korle Wulomo ni baho dani abatomo na tone leleng achole Nuumo Ayitey Cobblah ni jenyo ke iya wo mi hu ake a Wulomo must of necessity come from Korle Wu and must trace his lineage patrilineally in the Korle Wu kabawo Wulomo esani Wulomo eje Korle Wu ni jeni esani eje Korle Wu keke shimon esani echese hu aje Korle Wu. There was a dispute between the Gbese Manche and Korle Wu ke eje anukwale ake be ko ne wu no mi Gbese Manche ni yo eke Korle Wu sane ya metin. The point of dispute is that while the defendants claim the dispute has been resolved, the plaintiffs allege the contrary. lelen ake enushishia alo wo mi ake lele na kan time no mi gbese manche ni yo ke Korle we sane ejeme shimo keji obo defendant atu keji obo Nuumo Okai me to Nuumo Okai me ke na kan sane ni yo gbese manche ke Korle we ten na kan sane as akwe ni ayue asa shimeni ke sane ba me ke dabi na kan sane asako no peji mingblamo ni yo me enyo kui enyo nen aten shimo eji anukwali ake na kan bia mi lele no mi sane ko ye gbese manche at the time ke Korle we be aten. Number 4, where there is a substantive Wulomo, it is he who heads the family. Jeke ni ina nwake eji anukwali ake keji Korle Wulomo ye Korle Wulomo leji Korle we fe icho. Number 5, the 4th and 6th defendants hold offices in the family and live in house number D408/2 as of right. Ni agbene we ina ake lelen ake defendant moni je jono ke ekpa no lelen ake ameyo bena. They hold offices ameyo bena ni ameyo ye wekushia ye wekuami ni je ni bena keke ni ameyo ye wekuami shimon ake shia me de nche jame je na ameyo jame je na ameyo. Finally, the father of the first defendant was once secretary to the Korle family. Plaintiff, however, claims he was from Sempe. Jeke lele ake Nuumo Okai eni nke ba ke Nuumo Okai papa ji first defendant Nuumo Okai eni jeke lele ake ina ake lele eni eye wolomalo ke Korle we eni ye wolomalo ke Korle we shimon meni ke sane ne ba ne ameke je Korle we sheje Sempe. I will now proceed to consider the relevant issues set down for trial. Jeke ka agbene ni bi na keba ni esani kweno ni wa ye mabote mi agbene. I will now proceed to consider the relevant issues set down for trial. The first and second issues will be taken together. Whether or not first plaintiff is acting head of family, of which the other plaintiffs are principal members. And in leleng ake wachene enye meni kesani ba here and lela kele edumo Korle we onupa najian because abe Korle we icho because abe Wulomo ni lele wake meni me fit here amehu Korle we onupa ji amelo. And whether or not first plaintiff was appointed acting head of family for the sole purpose of overseeing the burial and funeral of Nuumo Ayitey Cobblah II. Once again, I used to ni because boli money type. Now, yeah, kama sama kwa wake anike lele Korle Wulomo ichoe ani naka gbana akehale koni ekwekeke ni afu Nuumo Ayitey Cobblah ni jienyo na egboe alo eba ye naka gbana kefe ni bi konklome hu. The plaintiffs pleaded that the first plaintiff is the acting head of family of Nuumo Korle, and the other plaintiffs are principal elders of the said family of the other plaintiffs. What the first plaintiff said in his evidence in chief was that the second plaintiff was deceased. Okay, repeat the next one. Without giving any details, he said they help him to perform customary rites in the family. In respect of his own capacity as head of family, this was his brief testimony. It is not true that the Gbese Manche acts in the absence of Korle Wulomo. There was a dispute between Gbese Manche and the Korle. I was asked to supervise the burial of the Wulomo and see to the installation of the next Wulomo. Afami akenkwe ni afu Wulomo ne choice ni di Nuumo Ayitey Cobblah ni jienyo koni no se hu emakwe koni ato Wulomo konkron ni ibacha nikegbenano. The dispute with the Gbese Manche has not been resolved. Saneni yo Korle we ke Gbese Manche te na kan sane ayeku atako. The defendants disputed the capacity of first plaintiff as acting head of family, contending that the Wulomo is the head of family in Korle, and that in his absence, the Gbese Manche acts until a substantive Wulomo is appointed. Many men are yes, Sania, a shama megadabi, money you are jay nakaini. Ke Korle Wulomo be, bese manchaji money you and a jam. Ke atabiami, ni abato, Korle Wulomo. Conclude. Now, since the defendants disputed the capacity of the first plaintiff, the latter bore the burden of proving his capacity. To discharge that burden, he tendered Exhibit A, an invitation letter dated 28 April 1998 from the Korle Youth Association, addressed to Mr. Pete Darby. Ow. Yeah, me buy a fight. Yeah, I'm once again. Yeah, me once again. Me buy. Okay, agban attention again, but no go. Yeah, me once again. If I get boy, lawyer, and kwemi, lawyer get again no go about. Yeah, once again. Lawyer and chomi no go be benyana. Well, why I go law school? Yeah, lawyer Jimmy. Kenya get I can swear. Law je bluff on ye. Intibly yemi. Okay. Yeah, once again. Type it draw attention to no go. It can no go fit aye. Okay. Thank you. Okay. So lawyer ke judgment ke judging ma in parts can claim eba na pleading say ni chwa ni bi ni akeba na you no ni mene me ke no ni mene me unke agbene the issues for determination no ni agbene aba akpene mo fe mo ba agree mo fe mo ba akpena ke energy no ni wo ba yue lele kenya ko boni nkan lele na ke pepe follow ke ka agbene anwe agbene odase ni. Thank you, lawyer. Thank you. Got you. Eke agbene keke agbene nwe odase ni me ye keke no akeba bona so lawyer ke earlier on ni min kan odase na ba ye min ka ke je na kan ni meni me ba ye odase no ni ameke if I get beni mi we third defendant agbache sane yes min ka ke je da bi. So me read in the eyes of the judge, but Janake, no can abo money by you. That's no na you ake. And the third defendant said this. The third defendant can again, but I kept saying ake. Thank you. Got you. So that was a mistake. So lawyer ke bako agbene ishe no ni je election na you mo ne no agbene manyama ka ke je ke. Bona she benimin can na can third defendant tell you money agbache. I kept saying I can je that be ni le na you money you no jino no me mean can me have even though je owner so thank you lawyer intibri me. So lawyer ke bia na agbene no ni mean can no ni je you agbene no jino first third defendant a testimony and neighbor no the meaning can in the process I mean ke so lawyer ke na kaini. Thank you lawyer thank you I appreciate you. Now where biane the relevant paragraph of Exhibit A reads, we are again by this letter inviting you to Korle on 1st May 1998 to witness the appointment of Mr. Ayanan as the acting head of Korle at 9 a.m. The first two paragraphs of Exhibits AI A1, I think, yeah, A1, because the letter and the number. The attached resolution are relevant and will be reproduced for effects. It reads, at a meeting held at Ashoma in the premises of Mr. J.A. Annan by members of the family of Korle clan, it was resolved that a funeral committee be formed to see the burial and funeral of Nuumo Ayitey Cobblah II, the late Korle Wulomo, who died on the 9th September 1997. Statement of claim says 1995, which is wrong. So, KG defendant say wachane atole Korle Wulomo pe ni no atole acting head awole icho ni eba kwe na fun Korle Wulomo na egbo ameke no pay wa atole shi atole ni eba ye Korle Wulomo ahun ne kwe na fe kusumi na atome ke ni bi but no the burden of proof is on them to prove because meneke no atole no exhibits na meke ba no jino ni akan your name. However, it was unanimously agreed. If I'm losing train of thought, because Bolly Sanima Bo lawyer to so let's go on. It's good. However, it was unanimously agreed that Mr. Ayenan be appointed acting head of Korle to make up the duties of the late Wulomo till a substantive Korle priest is installed. Nagan letter me ni amekane na ametashi a chono gwage nagan pe me agree ake Mr. Ayenan esanang melegbe ni eyano ni act as Korle Wulomo kata biani ni abato Korle Wulomo dienche ni eba tunien. It is clear from exhibits A and A1 that the first plaintiff was appointed by the youth of Korle for the limited purpose of performing the duties of the Wulomo and overseeing the funeral, the burial and funeral of the deceased Nuumo Ayitey Cobblah and the installation of a successor. It is clear from exhibits A and A1 that the plaintiff youth of Korle Oblantai ni Korle Oblantai ni Korle Oblantai ni Korle ame lela ka me to neke Mr. Anane ni ebakwe ni afu Korle Wulomo moni egbo keke no se mliye etu ekusumi kwani ekwa ni atomo conclude. Now, in disputing the claim of the plaintiffs, the defendants deny the existence of head of family in Korle still many akesane ne be hia ma megeda abi no ni webi na enwo ake awo weku icho ye Korle na kan no ebemi. They contend it is the Wulomo who is the head of family, and when he is absent, the Gbesemanche looks after the household either by himself or appoints somebody to act on his behalf. Eke defendant say ke dabi keji mene meke awo weku icho Korle ebemi nakai keji Korle Wulomo be Gbesemanche leji money eba kwe Korle shiano either ledi enche eba kwe alo eba formuku nimo aba kwe Korle on his behalf ye na jam. This the plaintiffs deny. No way cheme ni kesane ne ba amegeda abi nakano je anukwale ni. The significance of the defendant's argument is that the appointment of the first plaintiff by the youth was both uncustomary and unnecessary, as the Gbesemanche was available to perform the role assigned to the first plaintiff. So, chemene kake dabi nakano ebemi mewa keji oblantai ni yo Korle ame fole akele eye Korle weku ichwe nakano ebe kusumi eja ake keji Korle Wulomo be Gbesemanche jimoni efiomini ekwo ese. The plaintiffs categorically dispute the fact that the Gbesemanche acts in the absence of Korle Wulomo. Ameke dabi Gbesemanche kwe Korle Wulomo say. They contend that Gbesemanche is a chief and cannot be a Wulomo. Ameke Gbesemanche mancheni ni manche enye ye Wulomo. This is how first plaintiff addressed the issue under cross-examination. No first plaintiff niji money weku icho ne enye make sani ete ni ebata adeka amiye ni abi ena sanjinye no ni ewe ye ne ke position ne as to whether gbese manche enye ko Korle Wulomo say no na ewe ni. Question sane na abile ni. By tradition and culture, the Wulomo is the head. Abilake ye kusum bejiano to ke wani fe mo amiye Wulomo leji icho na jemone ke bane. When the Wulomo is alive, he is the head. In his absence, a head has to be installed. Eke ke Wulomo ye wala miye leleng leji weku efe icho shimo keji ebe wala miye esani awamoko nimo ebaye enajiam. Question: because there is no head in the absence of a Wulomo, that is why Gbese Manche looks after the household. Sani anak abile ejake ake dabi keji Korle Wulomo be Gbese Manche jimoni kwese newo be kokula be ake abake abe icho ye Korle Wulomo enajemo de keba eke dabi not correct. The fourth plaintiff, on the other hand, testified on the subject under cross-examination as follows. Question: Korlewe traditionally has no head of family. They have a family head, which is the Wulomo. Now, nyebu atwe, menye kai no ni first plaintiff eke. First plaintiff eke, keji Korle Wulomo be, ya wo miake keji Korle Wulomo ye, leji Korlewe icho. Nikeji ebe le awomoko ato enajian. Fourth plaintiff monifite niji edwamiye edwano le unye kwa no ne baake abile sani. Korlewe traditionally has no head of family. Again Korlewe abewe ku icho ejeme na jemo, they have a family head, which is the Wulomo. Egadabi woye weku icho leji Wulomo. Question asababile. So the Wulomo is the only head of Korlewe. No otoke wake ye Korlewe Wulomo ni yoje lepeji weku icholo na jemo ne kebane. In the absence of the Korle Wulomo, a regent is installed as family head. Lewe na jemo ne kebaji yake ke Korle Wulomo be atuomoko ye najian koni ekwese. But thus the testimony of the plaintiffs, despite their reluctance to concede, was to the effect that in Korlewe it is the Wulomo who is the head of the family. Ni chwanke befe beni ame sumona ame chole kete nego nokwe amena jemo ane fe fan ake leleng keji ye Korle Wulomo jimoni yo wekuicho. This confirms the position of the defendants that a substantive office of the head of family, independent of the Wulomo, does not exist in Korlewe. No jege ene kenkwe no chwanke abe wekuicho per se ye Korlewe ejake ke Wulomo ye leji moni efi omini yo Korlewe efe no leji Korlewe icho. So no ni nune ke no ni nane eke miake abe wekuicho office separate from le Wulomo. Ona abe a separate wekuicho office, abe separate wekuicho position from le Wulomo. Ke Wulomo ye leji moni yo ke be. Yes, I make ake sana wo mukoni ekwe na jankata biamini abato muku. No abe a separate family head position from the Korle Wulomo position. It is not separate. Korle Wulomo okay yeah le Korlewe feno. The dispute, however, is on the issue of who fills the void in the absence of the Wulomo. So jeke shisani amoji yake anikeji Korle Wulomo be namo kwese ani atuomoko ni mo yu na jen allow to moboni defendant say call Gbese Manche jimoni yu na jen. In other words, between the death of a Wulomo and the installation of a successor who acts no jejen bisani allow abisani. In other words, keji Korle Wulomo kogbo katabiami ni abato Korle Wulomo conclone na kan be ni yo neke ni bi enyone te Wulomo egbo abato Wulomo conclone alo ato Wulomo conclone be ni yo neke events neke ni bi enyone te na mojimo ni kwa Korlewe. The defendants, on the contrary, the plaintiffs contend a regent is appointed, and in the instant case, the first plaintiff was appointed such regent. Plaintiff said, "Menika sani eba meke keji Korle Wulomo be egbo before na ba to conclude atuomoko Nuumo Okai na jam. The defendants many men are akasani eba eshie akasani eba eshie ama me ka dabi ni ti Nuumo Okai we me ka dabi eji Korle Wulomo be gbese manche jimoni eyo enajian nyawa ya no. It will be necessary at this stage to resolve the issue of the role of the gbese manche in Korle we ke boni ebale iwo esani wo kwa ni wo botemi ni wo kwa ke mini gbese manche egbe na poten ya Korle we. Understandably, because the plaintiffs dispute the customary role assigned to the gbese manche in Korle we affairs, they led only scanty evidence in respect of the issue. Ke inu shishimon ake ni meni kesane ne ba ame ke gbese manche ebe bena poten ya Korle we wo odase na ameke ba odase e fa it is scanty e fa ona boni ni yo fa emi wa chon e ke ke enu shishinaga because ame ke look gbese manche back ekwe Korle we no ke Korle Wulomo be ona boni chon ke Korle Wulomo be awu omoko de you na gbese manche be no go fame again no odase yeli na ameke ba na kan no it is scanty e fa e bibio emi echi emi wa ona boni ni yo. Now, first plaintiff, however, stated without giving details that there was a dispute between the gbese manche and Korle we and that the dispute has not been resolved. First plaintiff name eyuake leleng saneye between gbese manche ke Korle we in the case sanene ayeko. This position is to justify the plaintiff's argument of the necessity for appointment of an elder to oversee the affairs of the household following the death of the Wulomo. Jeje nchono kwake neke juemone plaintiff ani wole koni emanomi yake because sane ye gbese manche ke Korle we te ni na kansane ayeko ewo no ewo ni eya ake esani atole koni ebakwe Korle we affairs. For the defendants, whatever disputes there was between the gbese manche and then Korle we was resolved, and that the gbese manche resumed its traditional role as regent. She many akasane ne beshine ama me ke sane fe sane ni yo gbese manche ten ke Korle we ten na kansane aye ni gbese manche boni kusu e kashi ya mewie momi boni kusu e kashi ake esani ekwe Korle Wulomo se ke Korle Wulomo be na kan pepe ji boni amechon. The defendants also regrettably did not specify when exactly that dispute was resolved. Yes, I'm a gbese manche sani ani yo le ten ke Korle we te akwe sani na aye Shimon amecho be ni akwe sani ni aye. Does the gbese manche act in the absence of the Wulomo as contended by the defendants? Ani leleng ake gbese manche legimoni ekwo Korle Wulomo se keji Korle Wulomo be to moboni defendant say you olo, or does the family appoint an elder to act in the absence of the Wulomo as stated by the plaintiffs? Allo boni plaintiff say you me nika sani ba boni ame you akekeji Korle Wulomo be awu oshi onu pako na ekwo ese katabia ne atwe conclude na kanji boni eyolo. Since it was the plaintiffs who asserted that a regent or acting head of family is appointed to manage the affairs of the Korle we, they carried the evidential burden of proving the fact. Ake me ni kesani eba ame ka ke Korle Wulomo be awo moko ke to enajian benuele ameji me ni esa ni ame chon ni waye ni wayose ni waye awomi ni wana leleng ke krede ake eji anukwale ake ke Korle Wulomo be ato wekuicho ne ekwe enajian because amame ke na kan no ba. This they failed to do in their evidence in chief and also under cross-examination. Under cross-examination, the fourth plaintiff was asked, nekeno kone ni ame esani ame hawo ni wale ni wanu shishiage lelen ake keji Korle Wulomo be atwo wekuicho ne ba yuenajian nakano amenye amefe nakan ye kotwe nakano amenye ni amefe bi amini abi money fourth plaintiff money fit am any je no me town no friend no ma gbale me ye gan me so fine get me money fit am any je no bi am ne ya de ka me ni Nuumo Okai defendant say lawyer bill sani under cross examination boni etene again. Can you give the names of the various Korle Wulomo from the time of Niadu the first and the various heads of family who nominated them with their elders? Again, Obanye Ochowo Korle Wulomo Swate Keje biamini ato Niadu niji kenkle ke wekuichi ke onukpai ni to amelo na jemo ne kebane. I can give the names of the Wulomo but not the various heads of family. Okay? Manyama chawulo me fe Shimon wekuiche ni to amele inye mache lawyer abilake. Ega I put it to you. Lawyer fu amesuma I put it to you. Ega I put it to you. Apart from first plaintiff, Korle has never had a head of family. Lawyer get bo. She no tane bo. Minke buake. Apart from money nye keleba ne Korle atoko wekuicho yejenna. Miniji na jemo ne keba. Again, there have been many heads of family. Oh, dabi lawyer. Wekuichi la ato baba oh ye Korle ato baba oh ye Korle ya wachano. It sounds misconceivable that of the many alleged previous heads of the family, the plaintiffs were unable to name even one. Mi anaka no le efemi na pe ni nu sisiake nyeke atowe kuiche baba oh ye Korle ni gaga che komepo nye che komepo mi nu sisinaka. It is equally worth noting that they could not call a single witness from the family to corroborate their version. Efele na pe wake ameche moko kula ne ba yo kaja me weku mi ne ba yo dasiake lela ke Korle Wulomo be awo we kuicho. The defendants, on the other hand, called Ayitey from the public records and archives who testified as defense witness 1, DW1. So, Simon, mena ke sani abeshi, amena me yuake gbese manche. Jimoni Korle Wulomo se, mele na me kana kanoko be mi, amenya me kemo kwa ba, ni mo aba yue ha me. She am a defendant say na make gbese manchaji money Korle Wulomo say am a blamoko the public records and archives na actually Ayitey neighbor eba yoda say ye na kan no. It tended exhibit 3 a report of an inquiry into the alleged bestowment of Taki Yabwe Gamanche in 1921. Let neighbor ekewoloba nekewolu ekeba report of inquiry na fe biamini akpa Gamanche Taki Yabwe in 1921 ekenwolueba. Exhibit 3 as an ancient document speaks eloquently of some of the customary and traditional gun practices in contention in the Eastern case. Jejeke neke bolone ni wache Ayitey ne je public records and archives keba eji blame wolu ni egblad ni bi pi ami keje balagan kusumi nke gani femoi ni bi ami eni egbla ekome ko sanene ni ayone. I shall refer to relevant portions of the report. Nke bobaya any potin ni sanene na yo nekene ko ne fita noko yemi ne fita ekwe. At page 13 of the report, C.W. Wellman found the following. It is relevant to mention that the Gbese Manche holds a special position in the Gan Constitution, being as it were the linguist of the Manchemen. Portion na kandi mini. Eji noko wulu ne sani wafe wa yosiake Gbese Manche egbena wa keji ebale Gan kramo ake kenkene leji gamajian cheme fe ochami le keha Gamanche denche Gbese Manche le dumo majian cheme afe na alo leji gama. I think that's what I'm reading. I think I'm saying it right. Leji ochami ye majian cheme afe na keha Gamanche denche. In case of the vacancies of the paramount stool, the Gbese Manche acts as Gamanche. keji gamanche be bese manche legimoni eyo gamanche najian. He also looks after the Korle fetish house when the post of Korle Wulomo is vacant. Wolue na keba no ni ke gamanche be bese manche jimoni USA na ka wolue mi no jeje a quote from wolue ke mini like bese manche le no e ko Korle we shia keji Korle we be Korle Wulomo be Korle we shia he looks after the Korle fetish house when the post of Korle Wulomo is vacant. So like bese manche no keji Korle Wulomo be Korle we shia legimoni ekono. This extract from Exhibit 3 corroborates the assertion of the defendants. Neke wolone na keba no ni defendants say you no me ake leleng keji gbese man keji Korle Wulomo be gbese manche jimoni kwese. I find therefore on the evidence that in the absence of the Wulomo, it is the gbese manche who acts as Korle Wulomo. Ena ye evidence say na keba mi ake leleng keji Korle Wulomo be gbese manche jimoni actor as Korle Wulomo. Again, now following this finding, it will be necessary to interrogate the validity of the first plaintiff's claim to have been appointed of family. Ake biane what you say ake keji Korle Wulomo be gbese manche jimoni kwese biane be ba yin ake wokwe ake anito ni wachene ko ake atole weku ichwe ani nakai no eji epapa nilo. It is true that the first plaintiff merely asserted without giving particulars of the meeting that appointed him the convener of the meeting or the elders and principal members present. He relied on Exhibit A as the authority for his appointment. Yes. A meeting ni atolewe kuicho. Shimon meeting echo moniche. Echo meni batala meeting mi. Echo wekuiche ni yo meeting mi. Ni aketole neke wekuicho ni eke Exhibit A ba. No juno ni inkande aboni youth maleta. Learned counsel for the defendants cited the authority of Abakan versus Ambradu 1963. I think it's Ghana Law Review 456 to submit based on holding one of that decision that the right of removing the head of family from office is vested in the principal members of the family, and the acts of the majority would be binding upon the rest only where notice of the meeting was given to all sectional head. So neke case na quote ne saneni aye ne chono gwake keji abafa abaje woku ichoko ye officer naka ewale onukpai ni yo weku emi amame yo naka ewale ni ameifale na keji ameifale. I don't know the majority. So come yeah, I may P ni yo neka weku emi come P agree. I'm a failure neke mabo. Come P agree akeshi afa neke weku icho ne but na kanji boni abayale. It will be binding upon the heads. Blavogen bagami. Consequently, counsel argued that in the instant case, since it was the youth and not the principal elders who appointed the first plaintiff, then appointment of the first plaintiff as head of family, even if true, is not binding on the family. So based on the case in it, counsel for the defendant say, "Did you Nuumo Okai me? Argue look, a case in a year. Echwake, keji abajie weku ichoko ye position me. Esani onu pai ni yo weku emi. Amameba atashi. Ni keji majority of them vote aka fale ye miye nakano eba hold shi keji wakwele tane ni wacheke ba ake atole weku ichwe alo afale aka ba ye weku ichwe ka kwa oblantai ji meni fale Chimo or T3, that's right. Chimo or T3, that's right. Thank you. Anyway, where you go, what you American you? When you blavo, I'm gonna if you are gonna. Is that why you got crown? What you? Te square na again no vernacular again call each of me. So ka wa gan fe one flexi one time mo fe mo anu age anage what you abla for wa asma one fe wo yi. Asma one fe wo yi. One time anage one no abla for wa asma one fe wo yi. Oh, Charlie. Yeah, me 1 second. Sademba, Sadekomba. That's right. Chamega nyame. Ye fenye yi ana walada wo be ko nya wo chado. The parties agreed. The parties agreed that at a point in time there was a dispute between the Gbesemanche and the Korle. The cause of the dispute was, however, not disclosed in evidence. It will appear that while this dispute persisted, the Gbesemanche will not resume its traditional caretaker role. Accordingly, the necessity for the appointment of somebody to fill the gap became evident. The first plaintiff was a principal member of the Nuumo Korle. The first plaintiff, a principal member of the Nuumo Korle, was appointed by the youth for the purpose. The defendants were equivocal on the status of first plaintiff. While first defendant conceded that first plaintiff was one of the principal elders of Nuumo Korle, the third defendant contended first plaintiff does not hold any position in Korle. This is how first defendant testified to the issue under cross-examination. So be aneboli, wache ni kesanieti, ake leji Korle ichoe, botemiolo whether is lele ake naka no aye no go na chole naka lo ni ke lele na tole te esane e yalete first defender ni Nuumo Ayitey Cobblah Nuumo Nuumo Ayitey Cobblah Nuumo Okai Nuumo Okai papa neke jiboni under cross examination answer neke sanene. Do you know that following the death of Nuumo Ayitey Cobblah II, the then Korle Wulomo, the youth of Onomroko Way, appointed first plaintiff as acting head of Onomroko Way? Abilake, Anyoliake Biami, ni Nuumo Ayitey Cobblah Boy, Oblantai, ni yo Onomroko Way, Amefa Wachene, first plaintiff ne, Akele, Eye Korle We Icholo, Nuumo Okai, Papake, that is not true. Dabi. Question. I suggest to you, the reason why the youth appointed first plaintiff as acting head was to oversee the burial of the late Ayitey Cobblah II and the installation of a new Korle Wulomo. Lawyer ke min ke bo ake no de wo ni oblanta ye fa ake wo chene ebaye Korle Wulomo icho ji ake ame fale boni afi ne ba kwe ni afu Wulomo na egbo ni ji Nuumo Ayitey Cobblah ni ji enyo ko ni le no ekwe ni ato Wulomo konklum miniji na Jemoni Nuumo Okai papa keba. Again, first plaintiff was just appointed an elder to oversee the burial and installation of the new Wulomo, but he showed no respect to us and left us unceremoniously. So we are the Nuumo Okai papa I admit no go ebie. Again, wachane neke wekuicho nie leleng afole neba ye wekuicho kodi ekwe ni afu Nuumo Ayitey Cobblah ni jenyo kodile no ekwe ni awo Wulomo Konklo was appointed as an elder to oversee the burial and installation of the new Wulomo, but he showed no respect to us and left unceremoniously. Shimo na kekbe na hale ebu ni eshiwo etajen keke. Now jejeke, I am persuaded on the evidence to all that in view of the impasse, okay, between the family and the Gbesemanche, first plaintiff was appointed by the youth to oversee the burial and funeral of the late Wulomo. Jejeke, me awomiake based on Nibiani na ake because na agbaye Gbesemanche ke Korle we weku ete wo oblantaye lele ake amefa wachene ni first plaintiff ne ni eba dumo Korle we na konye kwe ni afu Wulomo. Although the plaintiffs did not lead any evidence as to why it was the youth and not the principal members and elders that appointed the first plaintiff, the facts show that the defendants approved of the appointment, even if tacitly. Yes, even though wachane nye chon ake onukpai ke chemeni yo Korle weji meni tole defendant say echon ake leleng amele ake wachane atole Korle we icho, even though ka ame ma no mi ame fetu ame chon ame bem yo jogba la ame yue lo jogba ame ke yue mo ma shi ame fe ni ene ba ma shi yo jogba still manyama ka amele ake wachane atole ni ame megbe na atole. From defendants' evidence, first plaintiff acted as head of family, at least up to the time he allegedly disrespected the family and left unceremoniously. So tumobeni onani jeje ke Nuumo Okai papa no ne yue jeje ke ken kwa mi na ke leleng at least katabiami ni amame susumo mi ameke Nuumo ebu ame na eshi ame here wo mi ake leji weku icho at the time. Challenged to prove the alleged disrespect shown by first plaintiff, third defendant said at a meeting he was only interested in items 13 and sometimes he would go wild. Ni JJK third defendant echon ke first plaintiff wachaneni le eke atole ne actors we kuichwe amecho amehi atwa ni eche echon egeka at a meeting le item 13% yo ni sometimes I got a meeting Yege jiga be from when you be you are making be item 30 over go 30. Okay, so I correct me. Okay, please, youth in means oblying Koblaye. Oblantai are those from 40 going. Okay, thank you. So it's animal. I think about a good player. I tell 13 so they say you are. So more agma item 13 ni to get be am abo meat pie get fanta god item 13 fe mo menage item 13 wa meat pie get fanta meat pie get fanta cause mo mascatella meat pie cause mo coke awo coke we abo coke mi na get watch na esumo coke we wa coke Sumo koku wa you know like at a meeting e menoni a meet pie ke koku oh my goodness. It is doubtful whether this is sufficient ground to dispute the leadership role assigned to the first plaintiff in the family. At any rate, there is no evidence that appointment was subsequently revoked. Yeah. Things are you are there. I don't think I get a Jidoko Wulu now. I don't know anybody. I get Pamo. Atenere can come where no go clear chonake tone na tolene. I hate Nakan Bena ye a day. O find it. I will continue ya ko Jani Femo ni Okeha Moko. Now, Jaya Kamini, it is right that appointment of a family head is the prerogative of the principal members of the family at a meeting conveyed for that purpose. It is right. It is basic law. It is common knowledge. Basic law. It is common knowledge. Keji awo weku ichwe. Esani onupai weku nupai ainjeme. Meeting me ni ache. Akashi akbato nakaino. Esani weku onupai yemi. The evidence is lacking in the instant case. Ni nakaino keji wakwesa nene ni kanwo hiye ne ya wachane eweku icho womo miye wana principal members of the family wana onukpa ni yoweku emiye wana no kokulake ama ametashi na ametole. Once again onake oblantaye ni mawolo kin apita la ajete ake amensumone afele aka oblahin ko oblaye agani we naga oblahin ko oblaye ama me mawolo kin apita la ajete ake ame basumoni amefe wachane wekuicho. My understanding of the evidence is that while the dispute with the Gbese Manche persisted, there was the need to appoint one elder from the family, not as a substantive head of family, but as a leader or primus inter pares to manage the affairs of the family pending the installation of a Wulomo. So jajake is boni mani nustane nesi jake akeni sane ye Gbese Manche ke Korle wete ba hia ake abawo moko ni enye ma hie not necessarily ake awole wekuicho shimon abawole hie enye lo ona ye mani bu ahye efe abawo moko me ye mi keke mo enye ame hie eke akechu ni bi na sana atwu ye Korle we shi jeni awole Korle we icho per se ona boni ni shi awole moko hie enye lo because keme bu ahye sana na moko ne ba nye sana na moko ne ba lidi ona na kan position na ke hamo. It does not necessarily mean ake ale akele efe wekuicho. That is what the judge is saying. It was for that purpose that the first plaintiff was appointed by the youth. It is important, therefore, to see the appointment of the first plaintiff not in the normal sense of appointing a customary head of family to fill a substantive office. No, keji wana le na ke benwele wabanye waya wo miake leleng awole mone enye Korle we enye she no ake awole neba fe Korle we icho. In this case, it was for the limited purpose of addressing an emergency. Ni nakeno atole koni sane koni kanshi bi ane no enye ni akona kansane. I'm certain it was in the same vein that the first defendant pleaded that he was the head of the Korle prior to the installation of the Wulomo, knowing too well there is no head of family in Korle other than the Wulomo, as contended by them. Ni wache Nuumo Okai e papa e keleji Korle ichoe because eliake esani tumobene cho anahi enye loko she jeni awo weku icho because alaga Korle Wulomo le yo weku icho ni ke be gbese mancheji boni ko se shini be ye wo esana anahi enye loko le ni ame here no echo anke ne ke hi enye lo ne be atole Korle icho. In these circumstances, I'm prepared to accept as a fact. If a klalo while the dispute with the Gbesemanche persisted, the first plaintiff was appointed as a caretaker or leader of the family. Because Sunday Gbesemanche ke Korle waiting na kan bia mi wo first plaintiff e wo chene ne ke Sunday bane mayema wo miake lele atole. The fact that he designates himself head of family is a mere misnomer. The fact that can bear no edumo no ne kwake weku icho nie wrong title. Misnomer, wrong identification, wrong title. That's what misnomer means. It's a misnomer. He's giving himself the wrong title. Is identifying himself wrongly. From the foregoing analysis, I hold that the customary requirements for the appointment of a head of family, as stated in Abaka versus Ambradu Supra, as stated earlier, are inapplicable to the facts of this case. Boni defendant say a counselor a site na kan case say FA like na kan no e call ne kan sanene echo. Now, the plaintiffs did not establish the status of the third, fifth, and sixth plaintiffs beyond the averment that they assist first plaintiff to perform his duties. Since the first plaintiff stated that the other plaintiffs hold position in the family, they should have provided further evidence to substantiate their positions. Ni monijie teno enumono ke ekpa no nifite ye echo bena poteni ameyo other than ake amewale ni echu ekusumi ke shukwe eba sumo ake eba chon ekenoko baba ni ba gbla amegbena poten ni ameyo ye Korle. They should have provided further evidence as to what specific positions they hold in the family. In the face of defendants' challenge that some of them plaintiffs are unaware of the suit and may not have approved of it, the evidence offered by the plaintiffs as to the capacity of other plaintiffs is rather unsatisfactory. I'm not therefore prepared to support the plaintiff's position that by merely assisting him in the performance of his duties, the other plaintiffs are automatically principal members of the family. So yes, mind you, okay. Bemene fe ni fita wachene ni kesani e baye. Neke bemene fe wache Nuumo Okai we bi amekeke mene me je onukpa iji ame ye Korle we. Ona ni ake ni ame yue na kan shukwe eba sumo ake wache plaintiff ne moni nye yen ne kesani moni nye ma yen na kesani e ba eba cho me gbena poten na me yue Korle we. Shimon enye fe na kan. Ne wo enye kake uni amewale keke na afio kusumi wo benwe weku iche jiame alo weku nukpa jiame enye ke na ke ke mini. I will next deal with the issue of whether or not the position of Korle Wulomo rotates between three families in the onomoko Korle we. Ke agbenema kwe ake anilele ake Korle Wulomo yelie ani weku eteni yo onomoko Korle we ani ayoye weku etema lo. The plaintiffs pleaded in paragraph 3 of their statement of claim that the position of Korle Wulomo by custom rotates between three families in the Onomoko Korle way. Tumobeni nkani abwe amemena meke sani eba ameke Korle Wulomo ayoye wekui etemi. The defendants denied this averment in paragraph 7 of the amended statement of defense. Nakaino Nuumo Okai ke webiye ameke nakaino ebemi nakai. ebemi ake Korle Wulomo ayo eweku ete ye Korle we. It is trite law that all assets must prove. It is basic law. It is basic knowledge that ake money ko ake neke no ko yo bemo belasane chon. The onus was therefore on plaintiffs to prove with sufficient and credible evidence. Nwewo akeni eji common knowledge, basic law. Ake bomoni oko no ko ebu asano chon. Keji ameke ayo Korle we yeshian etemamie benue ekameno. Amena sana amechon na mani wole ake lele ake ayo Korle we ayo yeshian etemi. It is unclear whether the plaintiffs intended to abandon their position on this issue. This is because neither did the first or fourth plaintiffs who testified on their behalf offer any evidence on the issue in their evidence in chief. Eliake neke sanene ne fita sanjie na meke ba akaye ake Korle we ayo yeshian etem amlie. Eliake ame mena kan noi. Ejake na me batashie ni abi ame sanjina me batade ka mie. Nibi na me UF ame yue no ko poten chimo yeneke sanene. Yet it was only after they had offered sufficient and credible evidence on the issue that the burden would shift to the defendants to disprove the claim. Jajake boni mla akashie kanjame amenya me ba na me ba yue na make evidence ba agbene burden e ba shifty kaya meni ka je na kanie na mo amechon no na ewo ni mini ameka je na ken. And learned counsel for the plaintiffs did not address the court on this issue. I'm a lawyer lehu ne nyame here lehu ewe ne kesanene ye court. The scanty evidence plaintiffs adduced on the issue was put to the defendants when they were under cross-examination. Even though nakan sande poten aka yo Korle we ye ten, even though I may you na me lawyer we you na me can be poten ba na me ko support we nakan no any defendant say amebata adeka mi noni eteno ya nakan portion ne Nuumo Okai papa first defendant na bile nakan sande no na ewie ni. Question: I suggest to you there are 3 houses from which a Wulomo is chosen. Min kebo ake ayeshie ite ye Korle we na wo Wulomo ejame. Answer: I only know of one. Nuumo Okai papa ke shia kome penli na yo Korle Wulomo ye. Lawyer Bekom, I suggest to you the 3 houses are Odai Intowe, Aya Peko we, and Aduwe. Mi kebo ake shia yete na yo Korle Wulomo ye. Ayo yo Odai Intowe, ayo ye Aya Peko we, ni ayo ya Aduwe. Nuumo Okai papa ke je anukwale. Lawyer Bekom, I suggest to you, Wulomo rotates within the 3 houses. Min kebo ake Wulomo, Korle Wulomo, atwaye shiete. Nuumo Okai papa ke je anukwale ni. Question: Ayitey Cobblah was from Aduwe. Ayitey Cobblah ne egbo. Nuumo Ayitey Cobblah ni je enyo ne egbo ne eja Aduwe. Answer: I don't know. I was very young when he was elected. Ile ake eja Aduwe. Eja ke biamini atole bege fio ojimi ndako. Inye franco chon. Question: I suggest to you his successor would come from Odai Intowe. Ige not call me kebo ake ni le eja Aduwe. Ka ba to Korle Wulomo konkloe. E ba jo Odai Intowe. Na jemo ne ke baji. Ige je anukwale ni. The plaintiff should have testified to the succession of Wulomo and the houses they came from on a rotational basis. When the defendants denied that Ayitey Cobblah was from Aduwe, shukwe menike sanene ba na menka ayue ha make Korle Wulomo ayue shiete biami ni Nuumo Okai papa ba de ka mi ne jena aka na kan no ebe miye esani ame ba na me ba yue aka dabi nika yole ni shia eten ne atomene ebe sana me prove to court ake ama me no na me yuo aka eboleo nakanji nakan shia me fe nakan. Indeed, in the circumstance of this case, a more credible evidence would have been for plaintiffs to show the houses from which the 3 predecessor Wulomo to Ayitey Cobblah the second came from. Yeneke sanene miye esani shikwe po amenya amechon aka Wulomo ete ni ato before ato Nuumo Ayitey Cobblah ne esani shikwe amenya amechon shia ini neke Wulomo neje. Amenya me fe na kankwe shukwe ba wawa. It is highly unsatisfactory in the absence of any background evidence to allege that Ayitey Cobblah's successor would have come from Odai Intowe. Yeah, onyoba tashi no yue keke. Ake Nuumo Ayitey Cobblah monato before le mojo Odai dabi monabato after le esani mo aje Odai Intowe ni onyo choko meni menato before e ba she Nuumo Ayitey Cobblah no shia ina meje onyo ka keka ba to moko after le moje Odai esani mo aje Odai Intowe. At any rate, not having offered any evidence themselves to be interrogated in cross-examination, the plaintiff do not expect the defendant's denial under cross-examination to be taken as evidence, establishing their position on the issue. Interestingly, the plaintiffs did not establish by any shred of evidence to which of the three houses they themselves belong. Even though I make a no go back now, me bachon. I feel like I may expect that noni defendant say you here under cross examination about kwa woman. Shimo feel na pe ake. I me di enche na make sani eba. Keja make aye shian yete na yo Korle Wulomo ye mie. I me di enche amenye amechon shian yete noni mi na meje. Ani oje aduwe aloje Odai Intowe. Aloje mine ekomeje no ko peko we aloje jama meja amenya amechon na meje negeshia inemi. They failed to prove that the office of Korle Wulomo rotates among three houses. On the evidence, I hold that the Korle Wulomo is chosen from any eligible male from the Korle way. Ke amenye ni amechon ake lele ake Korle we ayoyeshia etemi. No ewo mi susu ake allow me ya wemi ake kaba wo Korle Wulomo mo fe mo ninu ni yakusun gbena enye yo Korle Wulomo anya atole Korle Wulomo awo Korle Wulomo yeshian ete mami. Issues D and F will be considered together. Issues D is whether or not, apart from the fourth and fifth defendants, the rest of the defendants hold any positions in the Nomroko Korle way, and issues F is whether or not the seventh defendant is customarily qualified to be installed as Korle Wulomo. So issues D and F, if I consider it together, DG and the defendants 4 and 6, I consider apart from defendant number 4 and 6, and the many issues your defense your defendants are there, and the lelake ame ye benako ye Korle we lo ni agbene we ba du mono no ne kwe ake ani eji kusung bena ake Nuumo Okai ani abanya tole Korle Wulomo lo. It was established by evidence, and both parties agreed that to be Wulomo, the person must of necessity come from Korle way and must also trace his lineage through the male line. Afela fang ni wafewa ya womi kaja me yenyone kuye nyone ni kasane ne baake keji obaye Korle Wulomo esani ola tokpa aje Korle we ye numli ye yomi numli. The defendants that's carried an evidential list burden of adducing sufficient and credible evidence to establish that 7 defendants' father is from the Korle way. No jeke yaneke wo many akasani eba eshia many ji Nuumo Okai ke we biye esani amenya ametwo wo akelela akele Nuumo Okai eche je Korle way ejake ayo yeche mli aye enyemli ayo eche mli no esani le many mena akasani eba eshia me esani amenya ametwo akelela ake Nuumo Okai e papa je Korle way. In paragraph 2 of the amended statement of claim, the plaintiffs pleaded that the defendants are also members of the said family, but hold no positions therein. That averment alone releases burden on the defendants to prove that they belong to the family. Plaintiff said, paragraph 2, ameya me womiake, mena me kesania eba eshie, naka me amege Korle we, ni naka yuemu okometo we, ani but none sani like How many eka defendants ano aka isane amame prove aka amejana kan weku emie naka how more naka no ni plaintiff say me ni ke sane e ba yue aka me ne ma me le aka ameje Korle we naka how more po ejio naka how more ya me no. There was no obligation on the defendants to prove their membership in the Nuumo Korle family in the view of the plaintiff's own averment. Yes, I mean you. Ya me statement of claim me yake mene me wali amaka meje Korle we no kokla awmokokla be defendant say no ake amena sana me twa ka meje Korle we meni ke sana e ba lenche yu ake mene me wali amaka meje Korle we nyeka yu ake iwe anye na me ka me li ameshi no ma 7 year pe di mo na me li. What they had to establish was the positions they held in the family, if any. Shimon, esani mon, amenya amechwake, ani lela ka me yogbenako, ye Korle we lo. In respect of the 7 defendants, since plaintiffs averred without exception that all the defendants were from the family, what the 7 defendants needed to establish was his lineage through a male within the family. In his evidence in chief, the first plaintiff testified to the defendants as follows. Shike abale Nuumo Okai no ni pene esane fe jiake esane enye chon ake lelen echese je Korle we no page no esane enye chon ake echese je Korle we because from 1 to 6 plenty fele nche he awomi ake amefe ameje Korle we no Nuumo Okai no ni pe Nuumo Okai esane fe page jiake esane enye chon ake lelen ake echese je Korle we. Now wacha ni nye meni ke sane e ba yen biamini abile sane noni ji ekene ye meni ameke sane e ba eshin eke komo. I know 1st to 6 defendants eke me paone ni wakasane ne be eshin ame keje kenklemo kashi ekpa no wale ame. They do not hold any positions in my family. Wale ame Shimon ame bekbenako ye Korle we. The 7 defendant, Papo Anan is known to me. Eke number 7 year uniji Papo Anan niji Nuumo Okai ilele. Shimon, he is not a member of my family. Eje inwekuemi. He comes from Sempe. Ilele number 7 year 7 defendant Nuumo Okai ilele mon. She eje inwekuemi. She eje Sempe. The 4th plaintiff, denial of the defendant's origins was more emphatic. Again, watch any UNA. Money J. John on if it here. Le no go J. Le ake ele mene ele amekula. Le again no le really wa danger. It was more emphatic. Like a really wa again. It testified on oath as follows. I know the defendants. They do not hail from Nuumo Okai. They hail from Sempe. So biamini first plaintiff 1 to 6 eleame Shimon Nuumo Okai page monije Sempe 4th plaintiff na many me oje eleame she ama me fe me je Sempe ame temo ko kla eje Korle we so ame yenyo fe they are on the same team she ame you any be different. Number 1 ke 1 to 6 eliaga me je Korle we 7 year pe jimone eliaga je Sempe. Number 4 le neighbor ega me fan me just Sempe. They are on the same team. I'm a UMO Bekomi. I'm a UShiami. From the very onset, there appears a serious contradiction in the plaintiff's position. Having pleaded that all defendants are members of his family, it is contrary to testify on oath that 7 defendant is not a member of his family. Fela nakwe ni elencha ko kwa mi oba nake ame yuemo fe shile no amelencha ame yu ame shia mi ke te fi ote ni yu ake me ni ke sane e be shie fe ame je Korle we Shimon number 7 le ke je weku nyoni. Again, having stated in his evidence in chief that 1st to 6 defendants hold no positions in the family, the same plaintiff set down issue D for determination, impliedly conceding that the 4th and 6th defendants hold positions in the family. First plaintiff stated on the oath that 4th defendant is the Korle Wayo. First plaintiff, 4th defendant, Korle Wayo. and lives in the Nomroko Korle Wayo, the Korle Shiami. He also said said defendant was appointed the Korle priestess 30 years ago and lives in the family house as of right. Moniji Ekpa, your defendant Moniji Ekpa no Lewu Korle Wayoni, Lewu Einjame over 30 years. A determination of issue D is that limited to the status of first, second, third, fifth, and seventh defendants. No ajaja ke eje fourth ke 6 yemi. No many measure ni about determine ake lela ka meje Korle we alo ame egbena ko Korle we ameje defendants number 1, number 2, number 3, number 5, and number 7. Number 4 ke number 6 eh aya wo mi ake wo ye ji ame na me ye Korle we so ame atwon me ni ji ame ke no na me yo klomo ye Korle we. Now, the positions of all defendants except the fifth were pleaded in paragraph 5 of the amended statement of defense. First defendant was the head of Korle we prior to the installation of the Wulomo. The second defendant is the Jaseche of Korle we. The third defendants, the kingmakers of Korle we or Agbache. The fourth defendant, now deceased, and whose position is not disputed by the plaintiffs, was the Korle Wayo. So the position of the sixth defendant, which is also not challenged by plaintiff, is the principal fetish priestess of Korle we, and the seventh defendant is the current Wulomo. On oath, the first defendant stated that the fifth defendant is the Sakumo Wulomo. The second and third defendants are said to be the Jaseche and Agbache, respectively, of the Korle we. The third defendant led evidence to the fact that his father, Tetekwe, and the then Agbache or kingmaker, and stood the last Wulomo, Nuumo Ayitey Cobblah II, and that he himself, the third defendant, lived with the last Wulomo in the Nomroko Way house for over 30 years. He further stated that the second defendant succeeded his father, James Ashon Ayitey, as Jaseche. Plaintiffs, on the contrary, denied the existence of Jaseche and Agbache in Korle we. So, I'm a trouble. Second, I'm a chairman. Ya me susu momie. I'm a care. Alo I'm a momie. I'm a care. Ato Jaseche na to Agbache. Ye Korle we. Me wo na me cheme gbo ni awame ni amemba ye ame chena jian. Third defendant le ekehi Korle we shiami for over 30 years. Me for over 30 years. No about me. Meanwhile, plaintiffs say many can stand back here. I better go na chole Jaseche ke Agbache. Yeah, Korle we. In respect of the Agbache title, the plaintiff suggests defendants may be confusing the position of Agbache to Agbache. The whistle. Here you go. So, cholo age many get sani aba amege abeno go na chole Agbache ye Korle we. Na me I'm confused Agbache ka Agbache. I'm confused na ka no she abeno go na chola Agbache. I Agbache. Alo Agbanfo ache. Be wole bonu wo chole. No me I'm plenty sen ka go me mele. I'm confused na ka no. Abeno go na chola Agbache. Now, nya wo cha no. It is worth mentioning at this stage that names and titles are featured prominently in this suit. Some of these names and titles have been spelled with slight variations by the parties. In this connection, it has to be said that that references to Jase onabona spellile, Jase no aspellile JC aspellile with GYS SI. The same thing as spellile DZACE. Jase no aspellile GYASETSE and DZASETSE refer to one and the same office. I will hereafter adopt Jaseche to refer to that office. So instead of GYA, JJK, if I adopt DZ with the spelling. As noted earlier in this judgment, the defendants tendered Exhibit 3, an ancient document from the archives to prove the fact of the existence of the title Jase within the Korle we. Once again, so I'm in proof. Yes, your Korle we, I Jaseche, your Korle we. At page 8 of the exhibit can be found the following. The Onomroko people of the Gbese quarter who are said to be represented by Afutu Kote and 3 elders who signed the charges are the members of the Korle, the servants of the Korle fetish, the say he be into parenthesis, Jase, so to speak, of the Korle priest. So wolone ni amekeba once again from Nanakeje archive said chonke lelen ayo Jase che position ye Korle we ameji say he be. The first plaintiff consistently denied the existence of Jase che at Korle we. Under cross-examination on 16th July 2004, the following transpired. Question: that Tetekwe Molai was at one time the Jase of Korle we. Answer: this is not true. He was made a caretaker. Okay. Bekode we Tetekwe Molai leji Jase Korle we. Ye Korle we first plaintiff first and yabioi. Monica nye menike sani eba nye. Egadabi I feel a caretaker keke. So at the time of the Tetekwe Molai, who was the Jase of Korle we? No, be a minute the Tetekwe Molai yo. No mo Jase ye Korle we. In Judgement at Korle we, we do not install Jase. The Jase is only at a place where there is a chief. Ega ye Korle we wo Jase. At to Jase ye any ayo manche ye. Lawyer, I put it to you that Korle we as a Jase. Bo no tashi. Min kebuake ayo Jase ye Korle we. Answer again no. Dabi question. And the Jase is the same as say be min kebuake. Jase I mean no me just say he be ye Korle we kake say he be ye. I mean no Jase na Jemode keba again there is no Jase at Korle. Jase is the same as say he be. That's interesting. If you have a question, I'll be like, I don't know. Okay, we'll get into that. Question. And the Jase is the same as say be. Answer. There is no Jase at Korle. Jase is the same as say be. But only lawyer you don't know you. Oh man. Oh, and this reminds me. Chameganyeme. Afi. Thank you so much, Afidos. Many one in a share donation no from Afidos. Keniaye. Wafe wache niaye. A donation eba. Wache niaye ke Afidos. Ame donation seba. So wache Afi. Thank you so much. You my job. Okay. Wafe wache niaye. Wache niaye ke wache Afidos. Mene ame donation seba. So nye yana walada nye waladon wa adenche. Ake wache niaye ke wache Afi ame donation say bagmene ye shiba mi ofane jani femo kiyamoko nlewe kiyamoko ni eba feta wohi ye shiba mi ke ni femo eyamoko yani wayano. Despite their consistent denial, first plaintiff's last answer weighed against the contents of Exhibit 3 shows either a confusion of thought or lack of knowledge of the history of Korle or a deliberate attempt to mislead the court. Yeah. But try again. I feel like I don't know whether ele Korle kusumi ele nibini ya anu Korle alo be efe yake ibala ka court to already yes. In Exhibit 3, Jase and Seyebi are used interchangeably. See page 14 and 21. The assertion by first plaintiff that Jase is the same as Seyebi is an indirect concession that the title of Jase exists in Korle. Yeah. The fact that she Jase I mean no Seyebi but it like ayo Jase ye Korle. Because it is the same as Seyebi. Exhibit B is an ancient document over 90 years and produced from proper custody. In Kessie versus Nami 1981 Ghana Law Review 445, the point was made that when documents are of such antiquity, they generally prove themselves. na kan wolu approve wolu ka jebre ma wolu ne jegbe che approve again. Whenever there was in existence a written document and conflicting oral evidence, the practice of the court was to lean favorably towards the documentary evidence, especially if it was authentic and the oral evidence was conflicting. See Yokwa versus Dua, 1992-1993, Ghana Bar Review 278. No, when the third defendant testified that the second defendant's father was Jaseche, and the second defendant was at the direction of the Gbesemanche, elected by his family to succeed his father, he was not challenged on this material fact. Once again, the third defendant you that say ne kake second defendant le eche ni Jaseche ni eche je ni Gbesemanche fa ake le eye eche na jia na ke no moko challenge ko. Brobe Judge Brobe, as he then was in the case of Hammond versus Moi and ANR 1991, one Ghana Law Review 89, amplifying the principle stated by the Supreme Court in Fori versus Ayerebi 1966, Ghana Law Review 627, stated at page 91 of the report thus: the law is quite well settled that where a party makes an averment and that averment is not denied, no issue is joined and no evidence need be laid on that averment. Let's go on. Again, similarly, when a party has given evidence of a material fact and is not cross-examined upon, it need not call further evidence of the fact. The learned judge also stated on the same page thus, ellipsis, where a party makes an averment and his opponent fails to cross-examine on it, the opponent will be deemed to have acknowledged sub silentio that averment by failure to cross-examine. On the evidence offered in this case, I find that the title of Jaseche exists in Korle and that the second defendant was elected to succeed his late father as Jaseche prior to the disputed installation of 7th defendant as Wulomo. So jeje echonogwake nonye na ye ko dase na ye ehia wo miake leleng ake second defendant aye noko na chole Jaseche Korle ni lela ake second defendant ni echegboe awole ake ebaye epapase. Plaintiffs rely on similar arguments to deny the position of Agbache in the family and consequently disputed the third defendant's claim to that title. The third defendant, who described himself as Agbache, said it was the same as the kingmaker and that he performs the instrument of the Wulomo. The third defendant testified that at the customary request of the Gbesemanche, he was appointed by the family to fill the vacancy created by the death of his father, Tetekwe. According to him, it was his late father as Agbache or kingmaker that installed the last Wulomo, Nuumo Ayitey Cobblah II. The first plaintiff stated he has not heard of the title of Agbache. The following is how he confronted the issue in cross-examination. Question: Korle Asan Agbache. Korle Agbache Yeme. Answer: the Agbache is the one who makes a canopy for the funeral rites of the Wulomo. Eke Agbache legimoni ke abafun Wulomo le fio canopy agba no ji egbe le fio agba ke abafun ke abafe Wulomo yala. No question akele so eye wo mi aka ya Agbache. She Agbache je le eke je kimeka ni Agbache le ka abafun Wulomo abafe Wulomo yala ne eshiun agba. Question: Agbache is the same as kingmaker of Korle. Eke dabi jenaka. Not true. It was the kingmaker who appointed Nuumo Ayitey Cobblah II as Korle. Eke dabi nakano jenaka. In cross-examination in cross-examination of the first defendant, however, plaintiff suggested what defendants, excuse me. In cross-examination of the first defendant, however, plaintiff suggested what defendants were referring to was rather Agbache. Once again, Agbache. Since both the first and fourth plaintiffs did not take part in the installation of Nuumo Ayitey Cobblah II, they would not be in any strong position to challenge the assertion of the defendants that Tetekwe as Agbache or kingmaker installed last Wulomo Ayitey Cobblah II. Jajake ake first and fourth plaintiff biamini ato Nuumo Ayitey Cobblah ni je no ame Benjamin ame challenge no ni third defendant na you ake papa Agbache na chole Tetekwe leji money eto Nuumo Ayitey Cobblah ni je. That conclusion, however, did not only absolve defendants from proving the existence of the title Agbache. Jajake first said no eje nagba ni eyo defendants ano ake amene sana amechon ake lela ka ye no ko na chole Agbache ye kolewe. Under cross-examination, first plaintiff stated that the Agbache is the one who makes a canopy for the funeral rites of the Wulomo. He denied that office holder is the same as the kingmaker. Wache ke aya Agbache shi Agbache le ka aba fun Wulomo le eshu agba keke na ge fun Wulomo na ke no efele ake legimoni etu Wulomo. In the cross examination of the third defendant, this is what transpired. No Shanena Bine, you testified in your evidence in chief that apart from Bese Manche and Jaseche, there is an Agbache. Oyoda siake ye Bese Manche se ke Jaseche se ye kole we aye bena ko na chole Agbache lo eke question, is it Agbache or Agbache? Ani Agbache alo Agbache you know tawo no you answer eke it is Agbache you know in tawo mache. Question, I suggest to you there is no position at Korle known as Agbache. Min kebu akebo abeg bena kokra ye Korle na chola Agbache na jemoji eke there is and is osiahini in tree eke ayek bena ko ye Korle na chole ye Agbache no jinoni no ni ye tree mi ye wo chola osiahini. I suggest to you what is known at Korle is Agbache. Answer, again, we don't have Agbache. What be Agbache? The question again, the Agbache is the head of fetish priestesses. Well, yake Agbache, alo Agbanfuache, you know, Agbache, leji wa ye fe, alo wancheme, wajancheme fe onupa, dabi, je no sani, je no nchonga ya Agbache, je Agbache, wa ya Agbache sande you all. Question, the Agbache is invited to the installation of any new Korle Wulomo appointed by the family. Okay, Agbache ne keji ato Korle Wulomo agenile sani abiole agenile enyo waji achema na achole keba le ba fio e ba fitai na jemo ige dabi afi na kai. From the foregoing evidence, the contradiction in the plaintiff's position is clear. After initially stating the Agbache is a canopy maker, they later state she is the head of the fetish priestess. Once again, the contradiction. The plaintiff also failed to establish the former or current holders of the Agbache office they refer to. Position. Position. Shinagamo jeleji osiahini jeleji moni eto Wulomo shimo leka afe yala pe ne ba shion canopy bona ameyue mwenyo je no pe unpo shiga mega ya Agbache position amenye ko na amechon me ne ba ye na kan Agbache na position na amechon. When third defendant testified that his deceased father was the Agbache who installed Nuumo Ayitey Cobblah II, that piece of evidence was not challenged in cross-examination. The third defendant we akele bi aneleji Agbache ni le eba ye chenajan e cheji monito Nuumo Ayitey Cobblah ni jenyo moko e challenge na kaino ni ewe. The strict rule that where the evidence led by a party on a material fact and is not challenged by his opponent in cross-examination, and the opponent does not tender evidence to the contrary, the facts disposed to in that evidence are deemed to have been admitted by the opponent and must be accepted by the trial. Mlaji kaji mokotashi ne yuenoko ni nakaino oyue ake nakaino je nakaini ni oke ni bi ba ni ba atwa aka no ni mo ewie je na kan ne be no ni mo ewie court we ba ye awo miake na kan ni no abo authority ni asite ejeme. Since the first and fourth plaintiff admitted they did not take part in the installation of Nuumo Ayitey Cobblah II, they will not be in a position to challenge the defendant's evidence that third defendant's father as Agbache installed the last Wulomo. In the light of the inconsistent and unconvincing evidence offered by the plaintiffs against the evidence of the defendants, the court is persuaded to accept the version of the defendants and to find that the title Agbache exists in Korle and that third defendant is the current holder of the office. Akene yuenaka nimo kwe challenge ile nimo ko kenoko ba ninu ne yue abaya wo mie jejeke obaya wo miake leleng gbena ko ye Korle ni achole Agbache ni leleng eche jimoni eyenaka position ni biane lewu eba echano. Having disposed of the status of the second and third defendants and the positions of the fourth and fifth defendants having been considered by the plaintiffs, it is only left for those of the first and fifth defendants to be determined. Although paragraph 5 of the amended statement of defense omitted the name the fifth defendant, the evidence of her status was supplied in the first defendant's evidence in chief when on 27th April 2005 it testified that the fifth defendant was the Nuumo Wulomo. The plaintiffs did not dispute the status of the fifth defendant as Nuumo Wulomo. Indeed, the only time the first plaintiff mentioned fifth defendant in his evidence was when he asserted under cross-examination that Nuumo Wulomo and Nuumo Wulomo sanctioned the seven defendants' installation out of ignorance. This assertion, independent of the customary role assigned to the office, is an admission that the office exists in the family. Plaintiffs did not name any holder of that office other than the fifth defendant. I find, therefore, on the evidence that the fifth defendant is the Nuumo Wulomo of Korle. Hey, Korle Nuumo Wulomo. Allow mistake in a mistake in a yes, Nuumo Wulomo. This brings us to the position of the first defendant. He pleaded that he was the head of the Korle prior to the installation of the seventh defendant as Wulomo. He named his father as Judge Okai Annan from Korle. So abotemi. The plaintiffs, after pleading in paragraph 2 of their amended statement of claim that the defendants are also members of their family, testify under oath that the first defendant is from Sempe and holds no position in the family. It is unclear whether by declaring the first defendant as coming from Sempe, plaintiffs were disputing his membership of the Korle. If that was intended, the evidence will contradict their own pleadings. Jajeke, medike sanene bane, ameywe, ake from number 1 to number 6, say, ameli amefe ka ameje Korle. Shimon, na we batashi na abi amesani, under oath, ameke, number 1, niji, Nuumo Okai papa, leje Sempe, jajeke, keji naka no ameta wana amechon benu amelenche no na ameywe ye shishije ka gbe no ne ameba na ameyuo benu ekele pagbe amelenche ameywe ni bi enyo. They are speaking from both sides of their mouth. Ameywe ni bi enyo ka chon bi ameka neke ka amechon bi, and you can tell like throughout the case ni bi enyo so ameyuo ka chon bi ameka neke ka chon bi ameka neke mene batabi eke neke mene batabi eke neke amedi encha ameywe mo ka amencha. It emerged in the evidence that at some point the first plaintiff instructed Alajete as counsel for the family to sue one Dr. Planch. In that suit, one Christian, Aya Mensah, described as principal elder of the family, was sixth plaintiff. First plaintiff admitted under cross-examination that the said Christian, Aya Mensah, and the hearing first defendant are brothers from the same father. Same father. Achono gwake. Yes, sane komina ye. Ni ata ona su neken Dr. Planche. First plaintiff ne papa ne neke sane ebane. Moniji ekpano. Ni fita neke sane ne na ayasu neke ayasu Dr. Planche. Moni fita ye ni je ekpa. Leji Christian aya minsa. Ni neke Christian aya minsa ne. Fe eke Nuumo Okai papa nyeme jiame chekome for me kenya ba kai Nuumo Okai papa neta adeka me e check Christian aya mi sane e check nyeme kan be check Christian aya mi sane ona so in the face of the clear admission, it is incomprehensible that the first plaintiff answered the following questions with a contradiction. So what way? Your case is conclude me, Your case is conclude me. Christian Ayane fita first plaintiff ne ate asu Dr. Planche. Ya ne case ne me ne Christian Ayane enyemi nu ni ekelefe papa komie e ke na kan enyemi nu ejesempe. Ni di Nuumo Okai papa. Oh, Charlie, very Saturday. Very Saturday. Saturday na why over there I'm going to know the Yahweh. Jadi Febo. Giamogo. Never fit away. Oh. Egale fe chekome shile jesempe bina adopt le. Oh yewa. Nyawa bi asande na bia no na ewie ni. Question. I put it to you, but in our big first plenty first and I put it to you. First defendant is a member of Korle and a principal member. Answer Gabaji. Egadabi. Ejesempe. How can plaintiff accept Christian Aya Minsa, brother of the full blood to first defendant, as a family member and reject that the first defendant membership of the family? Oh my goodness. How can you accept plaintiff? Okay. Eya Korle she nyemi nekeleje tutui kobena. Enyemi nekeleje tutui kobena ogele ejesempe. Bina adopt le. Mi bisandi adopt it. The plaintiffs admit fourth defendant is the fetish priestess of Korle. They are aware. They are aware first plaintiff is fourth defendant's daughter. You see, on a bunny we quete issue in yashi. Nyekwa, come be an ending can because wasumo anu kwale yeli. You understand? Wasumo anu kwale yeli. Wasumo anu kwale yeli, and it is really, really sad. Come on in kane abone no. Come on. The plaintiff admits fourth defendant is the fetish priestess of Korle. They are aware first plaintiff is fourth defendant's father. The first plaintiff is fourth defendant's father. So check it. If first defendant is not a member of Korle, his daughter cannot belong to the family. From the totality of the evidence thus far, the plaintiffs have themselves admitted first defendant is a member of their family. They have also conceded that his brother from the same father, Christian Aya Mensa, is a principal elder from the family. In the light of this evidence, the attempt by the plaintiff to deny the first defendant membership of Korle and status of an elder of the family is a lame attempt to dispute an obvious fact. Look, I mean, Jamena, you emoy, Kameni Femoy, FL Fan Ake, Nuumo Okai papa, Eja Korle, because I may a woman, Ake, Echebi, near Chole Christian Aya Minsa, Onupani a Korle, Sanya no vekete. Now, I ask you, Dr. Blanche, le efitai Christian Aya Minsane, efitai nege Nuumo Okai papa, cheko maybe jame. So onye no kake enyemi aya le eje kolewe she le eje sempe jaja ke ye no fe no ni nka na miye plenty fe meni ke sanene ba amenya ame deny ake lela ke Nuumo Okai papa eje kolewe. I find on the evidence that all the defendants are from Korle Way and hold positions in the family either as specific traditional office holders or as principal elders. Look, ya nibi na ke ba afen o da se yeli na ke ba afen ni na mi ya wo mi ake lela ke me na ke sanene ba afen ame fe ame je Korle Way ame fe aje Korle Way na me je Korle Way keke ame ye gbena ni ka me be gbena ko me kra na me yo Korle Way ame ti ame ko onu pa iji ame ye Korle Way. Now what chan? Now what we na what? It's on 5 pages. What back been on 5 pages. Now, is the 7th defendant customarily qualified to be installed as Korle Wulomo? To qualify the 7th defendant, it must be proved he is not from Korle Way to disqualify the 7th defendant, it must be proved he is not from Korle Way or is not a son of a male member of Korle Way. Eke keji wabaywe ake Nuumo Okai esani atole Korle Wulomo benwele sani wanye wachon ake le Nuumo Okai eje Korle Way je wa ke je Korle Way keke nwe shi echese eje Korle Way. The plaintiffs sought to prove by alleging that he is from Sempe by virtue of his name Pakpo. The defendants countered by saying the name Pakpo is from Sempe, but it was borrowed. Again, plaintiff said, I'm again Nuumo Okai again Korle Way because actually Pakpo ni Pakpo awoye Sempe na jelo ameke na me yu ameke what je wani ake Pakpo je Korle Way gbe ni Pakpo lela ake Pakpo Sempe ni Shimon won magbe Pakpo ni woke wole. Pakpo was borrowed from Sempe and customarily conferred on the 7th defendant. Plaintiffs admitted that Sempe people can also borrow Korle Way names. Ake amemeni ameke sani eba ameya wo miake Korle Way bi nye magbe ke jo Sempe je minke amameke meni ke sani ete je ke amehia wo miake Korle Way bi hu amenyo amema from Sempe ni Sempe me hu nyo magbe ke jo Korle Way. Plaintiffs admitted that Sempe people can also borrow Korle Way names. Ni chwaga melenche na meke moje ni ne na yuake amakpako na ga wole na mekpene ameya wo miake Sempe me hu amenyo amema Korle Way gbe na mewo. I find as a fact that 7th defendant is the son of 1st defendant and is therefore from Korle Way. Jeke ene wo me here wo me clear there ake Nuumo Okai eche ji 1st defendant me wo lewu eje Korle Way. I further find that by that fact he is customarily qualified to be installed as Korle Wulomo. Jeke no ewo iya wo me ake leleng ake eche eje Korle Way because Korle Way bi epolenche yu ake Sempe me hu po nye ma Korle Way gbe na me wo shinu aka fa no fe no ni nkwa mi ya wo mi ake lela ake Nuumo Okai papa ji 1st defendant ni wa wo mi ake 1st defendant eje Korle Way because enyemi aya amensa I'm a man of a sunny eba. Ya me sane conclo mi ame ya wo mi ake enyemi aya me nsa ejegeme ni nekele je chekome mi enyenye kake le kome to ele je Sempe echeni ne wo mi iya wo mi ake Nuumo Okai eche je Korle Way ni lewu eje Korle Way no wo keje atole Korle Wulomo esa is qualified ejimoko ni abanye ni atole Korle Wulomo. Now I will determine issues G and H together. On the customary practice of selecting a Wulomo, the first plaintiff offered a very brief testimony. I reproduce it in full. The family meets to select a successor. The heads of the family meet to select a candidate. I convened the meeting of the elders. The defendants are not entitled to select a successor. Defendants are also not elders who would have been invited to partake in the selection of Wulomo. The fourth plaintiff also testified as follows. The head of family and his assistant are elders who come to install the Wulomo, who are the heads of family who meet to select a successor. The plaintiffs failed to provide the information. It has been found as a fact that the plaintiffs did not participate in the selection and installation of the last Korle Wulomo, Nuumo Ayitey Cobblah II. First plaintiff has therefore never before convened to a meeting to select a Wulomo. Onuni, one of the issues now you are whether defendant say I'm a be ni I'm a chore meeting na tashi ni awo Korle Wulomo ke plaintiff say amenye ko na amechon na kan no ame provide any information aka meeting ko ye ni ache na afe ni mokofa aka abatashi ni afe na kan no ni amehu bi ameni ato Nuumo Ayitey Cobblah ni jenyo amete mo go bejen so amelegbe no na achon no amenya ame batashi na amewie no na ameyo. When therefore he says he convenes a meeting of the elders, it must be understood to be saying that it was to have convened a meeting of the elders to select the successor Wulomo. It was established by the evidence that, barring any impasse, it is the Gbesemanche who presides over these matters. The defendants have argued that the dispute between the family and the Gbesemanche was resolved and it resumed its traditional role in the appointment of the 7 defendants. At the time, nakano akwe ni aywe ni Gbesemanche fa ni abachu kusumi efe ni achu kia Nuumo Okai. Plaintiff dispute this first plaintiff as leading elder of the family appointed to supervise the selection of a successor Wulomo did not testify to efforts he made in that direction between the date of his appointment and the installation of the 7 defendants. He categorically denies that defendants are elders of the Korle. He further states the defendants are not entitled to be invited to a meeting to consider the selection of a Wulomo. Yet the evidence clearly establishes that defendants are important members of the family. Indeed, it appears the plaintiffs, out of spite, are not prepared to collaborate with the defendants to ensure a peaceful succession. A few instances of this spite are the following. Although plaintiffs admit 4th and 5th defendants are office holders in the family, they argue they are from Sempe and are not position holders in the family. Echo Jene. I mean, I make a sunny about. I mean, ya wo miake me na make a sunny about she. Ejo no ke pa no. Ame ja me we ku ani. Agbena me no ameke ne ke gbemene ame je Sempe. Ame yue mu enyo. No ni jenyo. Although they don't know third plaintiff's father, they admit him as a member of the family and deny third defendant the same status, even though the two are from the same fathers. Even though ni monifita ame ni jete amele che amele che amela womi ake eje Korle we shinake mo le no enyemi ye the other team no amege enyemi la amelele amege enyemi la amelele nyele che sinye la womi ake eje Korle we eche bi tutu fita mene ma ye le nyeke nyelele jejeke ekonwe. Although they accept 4th defendant as a family office holder, they deny that their father, the first defendant, is from Korle. And they why are we miake 4th defendant there? One chenny ye Korle. Wale Korle ake Korle wo yoni. She mo ameno ame you ake o jeche. Dabi eche ni the first defendant je Korle. Itefete ni ye yo wo yo awo miake Korle wo yoni. Ni eche le nyege je Korle. They are ready to accept Christian Aya Minsa as an elder of Korle, but dispute his brother of full blood first defendant is from Korle. Ameya womi, ake Christian Aya Minsa, onupani ye Korle, because now I sue Dr. Blanche. If it ame na sue Dr. Blanche, sile no echebi, neji Nuumo Okai papa, amege eje Korle we she je sempe no je ke ona ene me fe ntwom ya ke me ne me ame tawo ni to enjola aba ame te ba me fe no ko na me ke ba me ne mana ni Korle we afi basa basa na wa cha no on the evidence of the considered view that first plaintiff's participation in the election and installation of 7 defendants as successor Wulomo was desirable but not indispensable, being only primus inter pares. Look, Monica Sania Balenche, to Nuumo Okai. Today, na tole, mi nage, naga no boli, ne chonke be, unupa fele, tele, just ne chon yen yellow keke, nana yen. His non-participation in the selection. Oh, that be Jenna can blame me, but Jake, Kaji first plaintiff, ayimi, ni, ato, Nuumo Okai, naga no ebahi, she no chonke, ke be mi be anya chokusu mi ejake le hie nyelo kekeni bona keje ya himi na ya to le ejini nkpakpani is desirable ejini nkpakpani she keje be mi but not indispensable being only primus inter pares ni to aga keje be mi no echu aka be ni fe mu anya afi because le hie nyelo kekeni. His non-participation in the selection, election, and installation of the 7 defendants is not such an omission as to render the process invalid. No keje be mi eje no ko wulu ni no bana kake Nuumo Okai to na tole na kano eja ne sa na kechuani. On the evidence, I am inclined to accept the more positive and reconciliatory view that the dispute with the Gbesemanche was resolved and that he resumed his traditional customary role in the appointment and installation of the 7 defendants as the successor Korle Wulomo. Lemo no ni na jelo you are no more batuni ejake amemoe amechono kwake ama amemeno fe no nisane nika ameke Gbesemanche te ayena kan sane ni Gbesemanche chu ne kwe ni afe kusumie ke ha Nuumo Okai. I hold therefore that the appointment and installation of the 7 defendants was sanctioned by custom. No me ya wo miake Nuumo Okai to na tole achokusung beno miake tole. The averment concerning house number D48 or D477/2 was drafted in paragraph 7 of the amended statement of claim as follows. 7. Meanwhile, the defendants have unlawfully occupied house number D408 or D477/2, Salaga Market, Accra, built by the plaintiffs as the family house of the Honorable Korle, where a lawfully elected Korle Wulomo and his family reside and have broken into rooms thereof, unlawfully appropriating properties belonging to the plaintiffs and with the assistance of hired thugs, are preventing the plaintiff from entering the said house. Statement of claim ne in Kaneabu. Nakano akeshia niama ni Korle Wulomo ke wekume ba himie Nuumo Okai ke webiye ameba koshia ame jushi ame bote twin komami ame lolo eni bi komi emine sane ame lo ni agbene we ame hai efon feloi alo basabasa feloi ni ame ba duma agboena ni ame pene na metemo ko baba shiami. The defendants denied the above averment and pleaded that the land and the building has always been in the name of Ni Tetekwe Molai, the second defendant's grandfather. Najelo eke ye na gaini. Neke shiane moni gbe mi ne yoji Ni Tetekwe Molai moni wonyemi ekomede fita woye eni. In his evidence in chief given on 6 July 2004, this was the testimony given by the first plaintiff in respect of the house. I know house number D408 or D477/2. It is the Korle family house at Salaga. The house was built by Odai Into family. That house stands for Odai Into family. It was from Onomroko that we had Korle. There are 2 houses, Onomroko Way and Korle in the same area. Odai Into first built the Onomroko house. I don't know if these 2 houses bear the same number. I have effected renovations to the house Korle, where the fetish is and where the properly elected Wulomo stays. Normally, the 3 heads who elect the Wulomo are to stay there. At the moment, We are unable to stay there because we are chased by land guards when we go there. There were no occupants before 7 defendant was installed because we wanted to install the Wulomo before allowing occupation. We have property in the house. For example, we had a drawer and in which we kept dues paid at meetings. Chairs have been taken. The door locks that we fixed have been replaced. So enable in kind of thing abu yeshia sande no ame you egele ne ba sashia ni mogobeje me amentana me to Korle Wulomo da dani mo ayajeme shia ni boli weku iche ete ni yo ne ke weku na emi ame ba hinjeme ke Korle Wulomo ke ni bi ni akpena ame na ba shia ya me de age land guards bajeme na juju ya me ni bi ke ni bi no juno na ewie. Paragraph 11 and 12 of the defendant's amended statement of defense deny the plaintiff's claim to the house and aver that the land and house has always been in the name of Nitetekwe Molai. The 2 paragraphs read. 11. The defendants deny paragraph 7 of the statement of claim. The defendants further say that the land and the building has always been in the name of Nitetekwe Molai, the second defendant's grandfather. The second and third defendants, as well as Nuumo Ayitey Cobblah, the third plaintiff, were born in the house and grew up there. The fourth defendant, who was appointed over 6 years ago, has always lived in the house. The sixth defendant, who was appointed over 30 years ago, had always lived in the house. 12. In further answer to paragraph 7, the defendants say that all those who lived in the house were either given birth to there or have lived there by right, and that all the Waye of Korle have a right to live in the said house owned by Nitetekwe Molai. Replying to these averments, the plaintiffs pleaded that house number D4772/2 was built and occupied by members of the Nuumo Okai long before the birth of Nitetekwe Molai, and that the said house was registered in the name of Nitetekwe Molai merely for the sake of administrative convenience. NFA ben kaning blan yung chombo ke taflache onuno ning kan yo shishin nke bomo de no go hini. Although plaintiffs pleaded one house built by them, their testimony on oath was that there were 2 houses. On Nuumo Okai and Korle in the same area. First plaintiff testified that Odainto first built the Nuumo Okai house, implying that either he, Odainto, subsequently built the second house, Korle house, or somebody else built the second house. Under cross-examination, first plaintiff was asked, now, I put it to you that neither you or the other plaintiffs have anything to do with the land or the putting up of that building. Answer: I put up that house. Who then put up the house? Was it Odainto, the plaintiffs collectively, or the first plaintiff as an individual? Kenkla me go Odainto ma. Agbenenwe the first plaintiff egelema. So jeje mbisani. So shiane namo maye agelema mo. Ani Odainto ma. Alo ame na me kesani eba ama me fe ko me na me machine. Alo le mone nye me ni kesani eba yin alo le kometo oji moni machine. Ame shu ame yin shi poto. The inconsistencies in the plaintiff's own evidence does not help their case. Again, after testifying that the more 2 houses in his answer to a question answered that Nuumo Okai and Korle are the same. Now, agbene lemoni ami ani wole ake ameka ye hien aye Nuumo Okai na ye Korle agbene le lo na ta de ka mi e ga ne ke hien na efe ekomeni wo hien akome no ba nyo chele Korle no ba nyo chele Nuumo Okai so je hien sure te enyo don hien akomeni. Once again, another contradiction. It is interesting that although first plaintiff did not know where Odainto was born, he was nevertheless prepared to deny he was born at Teshi. He also stated that Odainto lived in Ashoman and all his children and had all his children there. First plaintiff, who admitted that both sixth, fourth, and sixth defendants were born into the house and lived there as of right. On behalf of the defendants, it was contended that the building all belonged to Tetekwe Molai. The said Tetekwe Molai was the grandfather of the third defendant, whose father and all the children of Tetekwe Molai were buried in that house. Now, Najelo defendant say, I mean, Najelo illegal bear for defendants. So you get kiami. I'm a look because I get Sunday by Shiami. So Bass and I'm a Giamina. No, the mean charming Najelo. So I'm a look. Mena you are Jane. Me. In Tetekwe Molai. Shiane ma. A big and not be fair, be an no many make big and be fair, German no afwame. The third defendants and his siblings, including the third plaintiff, were all born in Korle. It was defendant's case that Tetekwe Molai lived in the house, had all his children there, died and was laid in state in the house. First plaintiff response was that he did not know of these facts. On the other hand, fourth plaintiff under cross-examination stated that Tetekwe Molai lived in the house as a regent to the Wulomo and not as a landlord. It would appear from their account that plaintiffs were uncertain who Tetekwe Molai was, where he was born, his family affiliation, where he was born and his family affiliation. This is what the first plaintiff said in cross-examination. Were two more pages. Two more. You mentioned Tetekwe Molai with respect to the Salaga house. Who are they? Abi first plaintiff agebo. Oche Tetekwe Molai yes lashiai. Namejiame. They are from the maternal side. In other words, yebi jiame. I put it to you. There is only one person, Tetekwe Molai. Okay, yes. That Tetekwe Molai was at one time the Judge of Korle. That is not true. He was made a caretaker. This was how the fourth plaintiff also addressed the issue when under cross-examination. So, first plaintiff, agbene monifita me the fourth ababile sandi. Tetekwe Molai grandfather of third plaintiff and third defendant lived in the house as owners. He lived in Ajemoji. He lived there as regent to the Wulomo, not as landlord. You cannot act as Korle Wulomo unless you are from the paternal side. Yes. So okay. Keji nyeke yebi keji obanyo act as Korle Wulomo. Beja luse oje hear me. Then obanye act as Korle Wulomo lo. She mind you now be first plaintiff ake Tetekwe Molai me imba meje eke ye abi jiame mokomi anifita erigi third plaintiff le neba yue eke he abi jiame no wona me yo gbena no wona enye actor as Korle Wulomo ke Korle Wulomo be so na from the same team on a contradiction there ko nya wachano. The inconsistencies in the evidence of the plaintiff is obvious. You short. Ni many kesani ba ame you fa ame na be kome nakan. Many kesani ba kenkwe ame fe ame na be kome mene you no conclo. If Tetekwe Molai from the maternal side, he would not have been made caretaker to a position exclusively for paternal side. Keji lela ke Tetekwe Molai eje yo se alo yo binie shukwe neke benane ake ebakwe Korle Wulomo se nake no anya ake hale eja ke no hear me ajo na yo. The plaintiffs initially tried to adduce evidence that there were two houses. Agbene we meni ke sanene ba ame can claim me alo shije mi ame yu ake shia swate nyoni. They pleaded they built the house but led evidence that Odai Into built the house. Now make a bar. I'm a Yuake. Eventually, they led evidence that Dabi. The plaintiffs initially tried to adduce evidence that there were two houses. Eventually, the evidence established only one house. Yes. She said, "Me na make a sani eba. Abe you ake shia enyo. Ayo nom roko we. Na ye Korle we. Say me ame chaki ame nabu. Na make a shia eko me penny." They pleaded they built the house, but led evidence that Odai Into built the house. Agbene we ame ke shia ama mema. Shi agbene na abi ame sani ame ko Odai Into ma. Kwamo he shia sani ayu agbene. Ame ke shia enyo. Agbene ame chaki ame nabu. Shia ba fe eko me. Agbene shia ame ka ama mema. Agbene say me ame ko Odai Into ma. Plaintiffs did not explain how at least some of the defendants, especially the fourth and sixth, came to live in the house as a right. Finally, plaintiffs concede the house is registered in the name of Nuumo Okai, but that the name was adopted for administrative convenience. There is a rebuttal presumption that the owner of the house is the owner in whose name is registered. There you go. Yeah, look. There is a rebuttal and presumption. Wafe waliake na mo yoshia na register mo conclude bani. Wafe waliake monishia ni legbe mi register. The plaintiffs were unable to displace that presumption in favor of the defendants. Considering the persuasive evidence adduced by the defendants, the few admissions made by the plaintiffs in respect of the fourth and fifth defendants, and indirectly of the third defendant, coupled with the fact that none of the plaintiffs lived in the house, I make the following findings. First, that house number D408/2 or D477/2 Salaga Market was built by Nuumo Okai. Second, that third, fourth, and fifth defendant and third plaintiffs were all born in that house. And thirdly, it is incorrect that it was registered in the name of Nuumo Okai for administrative convenience. Echo. Echo. Kaya, you're not going to chombo. Don't go anywhere. I have something special to show you. Let me finish. In Benanta, in your page 28, in your no going to town in chombo. Min bank chombo. Kaya, in Gamini, in page 28. Bona. In no go back chombo. Kaya. Waba saga onu. Waba saga kaya. Waba saga. Ina mfoni nkoni maybe asha mfoni 2024. So 2 years ago. Asha neke mfoni 2024 2 years ago. She ingaba chombo. No we kaya onu. Kaya klo nganaga asha mfoni 2024. Kaya ngwachombo. Now, it appeared the plaintiffs were not minded to seriously pursue issues K and J regarding the alleged unlawful break into rooms of the family house by the defendants and the activities of higher thugs by the defendants. The first plaintiff, in his evidence in chief, testified as follows: the three heads who elect the Wulomo are to stay there. We are unable to stay there because when we try, we are chased by landguards. Myself and those entitled to assist in the installation of Wulomo are threatened when we go there. He mentioned the properties they had in the house as a drawer in which they keep dues, chairs, and doors, locks, allegedly replaced by defendants. The relevant portion of the testimony of the four plaintiff given on 2nd November 2004 was as follows. We could not go to live in the house because the defendants have installed a Wulomo there. There are people who have been put there to stop us from going there. We had chairs, tables, and drinks in the house. We also have a little money that we had contributed in the house. I don't know what has happened to the things. The above evidence was a mere repetition of paragraph 7 of the amended statement of claim. What kind of chairs? Plastic, metal, or staff chairs? How much money was involved? The plaintiffs failed to mention the 3 heads who were expected to live in the house. This was important because if proved, if proved, it was these 3. Yeah, 1 second. If proved, Bona, if proved, it was these 3 heads and not all 6 plaintiffs who could legitimately complain of having prevented from occupying the house. Yes. Nibi ne fe na me chon. Ame yue ni bi ka nibi ne fe, me ne me fe again, 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 me ne me fe again. Fe. Fe se amenyeko ni ameba chon. Ni e ba yin aka shukun am ba nya me prove na me chon. Ni bi e ojogba shika abo na akoke ni bi che se na afite mi na afite na mo shika afite mi na aju che senje na ka akomo and rubber saying plastic chairs allow that they saying allow staffing chair be no chole Ghana staffing chair allow staffing chair mi na afite drawer shika na je mi ni shika ayo ho mi gani bi ayu na kanoko. The plaintiffs have never lived in the house and do not assert that any of them is one the 3 heads permitted to live there. Agbene wa me na me ba fe amete mo ko echo ake ameji iche yete ne sana me je me amete mo ko nkoshi am down. They also talk of chairs, tables, and money without providing any details. They also failed They also failed to confront the defendants while they were in the box. Indeed, the matters relating to these 2 issues. The whistle. Ofane, kwamo ofone no eyam yonu. The whistle. Kwamo ofone no eyam. Ishe. Okay. Right. Okay. Right. So let's go. Indeed, the matters relating to these 2 issues border on criminality, and it is doubtful plaintiffs would have countenanced such an act by high tax without lodging a formal complaint with the police. I find the allegation unproven and dismiss therein. No, na me UFA ke ja me ke lele abakuma me senji na jua me dibi na jua me shika. No, it is criminal. Yeah, once again, but na ke no criminal. Ni ke na kan lele ni efe ke efe le na pe ake ama file complaint ni ya police station ake no ni aba fe amene ke o na ka allegation say na me fe aka aba kuma me ni bi ye hia ni ake land guard say ba o na aba stop ame na me nya me ya hia mi o ke na kan no awo mi I find the allegations unproven and dismiss them. In conclusion, what be now? The plaintiff's claim is dismissed. Judgment is entered for the defendants. What be now? Signed. Nano. Non kani. In conclusion, the plaintiff's claim is dismissed. Judgment is entered for the defendants. So once again, sanene akete ashi Nuumo Okai ye. Akene sanene te ashi Nuumo Okai. Se miye e ayekuni je ke lele ake atole wulomo atole ojogbang. Atole ojogbang achonkusumi na ake tole lele sanekobei. So keji oyejeme no obi ake namoji Korle Wulomo based on nonin kane abone Nuumo Okai ji Korle Wulomo. All this while court ye sani omo ke Nuumo Okai ake leji Wulomo. All this while aye alomo 2011 still oyano ni ona ake Nuumo Ayitey Cobblah court we ye che sani na mekete eshi Nuumo Okai awo fe chafu ame lose ame win ni ekomepo nibi na metawo jeje wo fe chafu. So court we ye che 2011 ton ake Nuumo Okai leji Korle Wulomo. Now noni akete ni aye last week ake tumobe no le ona ganye ti ame pie nyele ne nye na Nuumo Ayitey Cobblah etu enu ake Korle e shiam yolo ake sani ate koni le Nuumo Ayitey Cobblah afan le ye shiami because aye ake je leji Korle Wulomo. So Nuumo Okai me this time around ama make sani ate koni afa mla afa court afa ni Nuumo Ayitey Cobblah eshishia koni Nuumo Okai aya ne yata shi ake Korle Wulomo ne tueni ake Korle Wulomo no jisane na ake tenye ni bi pi genoumi ni bi pi jemi wo baba ni wo batabie ni wo ba kane no mfe wo habo no na yue mo na yue no na sanjie na bi meni me bata de ka mi ni bi na bi ame na jie mo na mekeba ni onna kebole ncho ime no ko yega ka anye mokose ka ya kocho ka ya ko klante ka ya ko kakla aba wo bomo ni moko ejiebu ko bla nu njibu obla yo jibu no yega ka afote atwamoko ka kocho no ketwamoko aba wo bomo ni ka obomo oba ya je free kemoko ba chebu ago ya fe no ko Korle Nuumo Okai kotu ke leji Wulomo sanie na ke sanene ni min kan ya bone jele ke sanie te cheme na meti ame pi amenye Nuumo Ayitey Cobblah sa ama mekete na ye shi ame awu ma chafu ayemo Nuumo Okai se ke sane conclude na fa Nuumo Ayitey Cobblah ye shi a Nuumo Okai le une kete kotu ya manomi akelela ake leji Korle Wulomo wole eya ne ba shi ame ne ba eba chue ni ake Korle Wulomo ko ye gan ni o ko pene no ya kocho no akokakla o akoklante o yakote no na me ko memba shiami no ko ba fi ame aba wo bomo ni ka obomo o ba wo je me free mi tete imba yuen eko ihabo eja ke mi bubo koko ka ya kocho ka ya koklante ka ya kote aba wo bomo ni tabie iwo na wo chomine nye tajeme nye lo moami nye jami in le for a fact akeke nye temo ko fe rough aba wo mokomo oblantai ni yo gamashi mimbo nye kokoe sanie ke anu shishie ayo ye kotu nye na yano ye kotu wolo moko ake konoko noni nye fe nye ke chei ke dadei ni nye ke nye ni shomo ma France nye gbokusumi nye fite kusumi nye gbokusumi so min kpanye fai bonim shishi min kpanye fai nye ka afi anoko nye ka ya fi anoko kotu eye ake Nuumo Okai leji Korle Wulomo wasani ani wo bie one answer in like nyete amoko le nyete ame pi nyele akesane aye che sane aye eche bana mo ona boni ni yo sane aye eche so mi pa yen fai mi wo nye hie ko Nuumo Okai Nuumo Okai leji Korle Wulomo gaming ke kotu ke gbeno na chon na ketole fe eji gbe no kokula abeyi eji kusun gbena so Nuumo Okai ko ye gano obomi to e kotu ye 2011 ton ni Nuumo Ayitey Cobblah no na yue ni se so wale hu no na te kotu e se lose Nuumo Okai se ye ko so once again ka nu hihie ko supporter Nuumo Ayitey Cobblah bomoden ani akano fe no aya court no ni nanye no ni you no ni you because nye na infoni e kan gbe ni na enyeche ni anye dadei ni aken fangma ebe ime no maybe aboyin ma fa ke dadei keche yende. As a matter of fact, let me show it to you. Dani makpa kone ka fe to mo otabi e no you no ko ni no you o dabi mi enfe na kan inako na fangma ni afe na kan da Wulomo yeli de politics ni afe campaign can Wulomo yeli. You see some of you nye fi omi mono nye tumo you see ona ngene Kevin Taki can ni anda mala chesane na kan no afe campaign ye online can be for Wulomo yeli. No onim sisi no now nyani nke nye noni video ni na achonye koni nye na ake noni yuo je amale ni ina ko na afangma ni ti achole ten menye anyenye che kenibi kenye ma fa se dan mi na ko ekudan. This is not right. Nyani nke chwanye afe press conference na afe press conference go ni bi ekomeni ayu press conference mi de eshile no ojugba nyami zigili mababie ma twa maabo ni mano na ake mano no mshishine no wani nke ni bi ekomeni zigili we it is not entirely correct. It is not entirely correct. Ona boni ni yo. Now, come video this is not right. Ka fanga na ko ene ko dan. Nando. Every single person, organize them, you should be ashamed of yourself. And then Ega Kusumi. You see, Ega Kusumi. Listen, the film on you all way. Biane, ni organize na fe no konokwe, na fe ne kenokwe. Bow your head in shame. Bow your head in shame. Bow your head in shame. There is another one. Ni ona oblaye pi. Let me talk man and Nuumo. Let me see if I can find that. There is ona no ni oblaye inle money page you na ye. If it ma menya vana ka me pi no bla nu ko ne nye cho ke chon ye. Okayo page enu wana na kan no ye. Let me see if it's this one. Okay, here we go. There we go.
No just share for me. Look, can you to fame yes again? Can you to fame? No one take for granted. Let's show me. No, 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 no. Oh dear. Oh dear. No, I tell why. Mokonya lo mokoyi don.
Let's see. Okay, the whistle is sending me another one. Call them Amakwe. Okay, I think is it this one? Yeah, I think it's this one. Yeah. I think I can get here. Okay. I think I can know. Yeah. Let's see.
Hey, friend, I'm a nose here. Yeah, Teddy, like you want to tell me. What can you get? You can find any. What can you get your money? Many of myself, but I'm an American. That's the end of Moko Bay. You are not why you walk a war. What I do, what no way I walk for one. I
Nano. Kusumi. Mekumele. Hey, ekola je kwa mi. Je ne becho. Ne becho enye. Ebi era yi mo jole ndi. Yes.
Like I tell you, I can't agree. Oh, no, just share for me. Look, can you to fame yes again? Can you to fame? No one take for granted. Let's show me. No,
Ene ebe kusumi. Nyemfite kusumi. Nyemfite kusumi. Nyemfite kusumi. Ene afa inako na afangma yega. Nekeda indako. Bege bibi ojimi kena afafosa. Shimi inako. Ni afangma, ni afengma, afangma kusumi nekeda inako ekoda. And everybody, ne ani nekeno ko bow your head in shame. Bow your head in shame. Like I said, this is equal. It is Obanyo to any chobe Kevin Taki can near Damalaje. Neke no na te court to na Kevin Taki get anukwe she ane nueni maybe you be why ye court to a kunage. Mogwa wote kra na etele na wote na etele na genjo. Nakai. Lumoyelie de afe campaign. It is not a political position. Avotu lumoyelie avotu kusumi aketoa lumo avotu na waga go mene leji moni mambia fe sumo no wakele ya ni you bad disrupt the flow of the community. Well nye kwa na anyi ojoba kama go nu hihie nye ke ya court Nuumo Ayitey Nuumo Okai nkele ba ko bi eda shi Nuumo Ayitey Cobblah lenkele ba pa no nkele ba channel no severally ke Korle Wulomo ni asani ma yue Korle na asani alo no ko ni nu shishi Wulomo sani ewie no ko ni mambi nu shishi na aba shile mi nkele ba pa no nkenya ke nkele ye close. You understand? She waka mlan tuning waka anukwale ntuning noni ko to ke nya wo yi ano me waka ko mlake wede ne afe no ko ne sa. This is not right. Ye be ni wo ne keje Nuumo Okai we bi hu yajeje me mini baba anyways. So 2011 ojuno ni nkane abue wo makane tumobeni nke abue makane noni aye meji gbe tele oni bi pjb infodi ani gang ba chon wenu ni infodi ani gang ba chon wenu ni tada infodi ani gang ba chon wenu anu. So chemega yeme gambai ajagan asagan kemba this was in 2024 asagan kemba nyega ya nyetwi asagan kemba bai abanana ke ina ayo ke abanana ke nyega ya nyetwi abanana. So chemega yeme nyefenye yi ana walada wababa bie ni wo wababa chano wababa chano nyega ya nyetwi abanana nkemini abanana asaga kemba nyega ya nyetwi nyega ya nyetwi chekebi nyega ya nyetwi asaga kemba nka abanana afina abafe mini abanana nyefe nyeyi kush nyefe nyeyi ana walada. So wo baba bie eke wo ba wo baba bie eke wo oba kane no ni te no last week court noni onumene wo noni makane mabwe e ba se ba manomi ehabo. Na as a matter of fact eke no ko po ba fitai e ba mano ni kane e ba se eke no ko hu afitai ne ba fele fan moniji Korle Wulomo kamo na achọ kusumi mgbe na ke tole ojuba e ba fe fan wo no ni makani mabwe no numene ne e ba mano mi ne ba fe no ko fan. You understand what I'm saying? So nyefenye yi ana walada nyi waladon akanye indulge me for 4 hours what tashi what can neke no go ne shout out to you akuche wo baba bi wo eke wo ba kande new one na ehabo nyefe nyeyi waladon order. So there you have it nke asaga mini jilala ni mogobeje la mogobeje mini lale ya na afi mini lala ne ya na afi ale de twa de la de that was la de before the machine being paying five what donation say what extended to next week Saturday so finally yeah ishiba mi koko no back way bomodeni okay ono abasa fact nyani nke nie angma pano bona min kpabu fai bomodeni ukono aba what donation there for omanjo victim say bomodeni fe koni oyo bomodeni ukepia was bona I think we could do more. What bomodeni she like I said what feel better. Once again, I appreciate everyone ni a contribute so far. Ofani bomodeni ke ukono bakwe bomodeni ukono aba ni opia was onu ye ishiba mi nkpabo 5 bomodeni ukono aba ni opia ni opia was bona ni wabomodeni wa me ame chofa komo ke ame hospital ya ke ni bi yolo ona bonini yo yep yep there was so oh yeah panage boni biamini wagale UL nche beni wagale UL nche onye panage ewe na kanga kana kana go ba be hin ni le finse ni le kwa na efe ni onye pano yeso bona all right so chebeka jeme nyefe nye yi anawala da oba pe e bi e wo onu nyefe nye ke wo jino bye bye Jani femo no kiyamuko ona like mo show ami dan no shi ke no ba on ko mi gontini ya anwe bomode no wa mieko oba pe bi e wo eni no ni te no nyi se so wa ye kote nke no ba e ma bo ni mi ke bwa ke no ni onugbe ne e ba ma no mi e habo ona e ba ma no mi keke e ba se fe no ko fan e habo no e se je ke no 11 pages per any 29 pages so no e was e chen what no ba fe was e chen bona was e chen no e to mo be ni ke 11 pages in 29 pages. So no was a chen. So far the war, bomade no fit away. Kemo moko ni na we ba fit away. Ko ni na no kwale. Onu wo ba pe bi e wo. Bye bye.